have a very full agenda. We're very much looking forward to hearing the symposium. So I invite us to be prepared to start promptly at 8:30.
Chief, you ready?
Yes, ready.
And
If you are.
I'm just waiting to see if Guy wanted to put the lights on.
Yes. I can do that, Mayor. I know how to do it.
It'll make sure it gets nice and warm in here if we turn the lights way up.
You'd have to fight for that.
I figured I was going to.
Are those ones supposed to be on?
It's going to generate a certain amount of heat.
Let there be light. Now you may enlighten us.
That's why she's the Chief Justice. She can manage all the lights.
That's fine.
Good morning, Chief Justice Fairhurst and esteemed colleagues. For purposes of our audience, I'm Justice Mary Yu, co-chair of the Minority and Justice Commission. I want to begin by, first of all, thanking each of you for agreeing to host the symposium at the Temple of Justice. I know it's voluntary by the justices to decide to do this or not, and I want to express our appreciation that each year you continue to say yes. We remain the only state Supreme Court in the nation that annually sets this kind of time aside to explore issues and to educate ourselves on contemporary issues that touch upon race. Our court's commitment to eradicating bias and to ensuring that our courts are transparent and accessible to every person makes a difference to those individuals who come into our court system every single day. I believe this annual symposium not only sets us apart from everyone else, but it helps restore public confidence in our desire to do justice. I especially thank Justice Deborah Stevens, who serves on our commission, and I also want to take a moment to thank Justice Charles Johnson for his long-term service to the commission for almost 20 years. So thank you, Justice Johnson, for the preservation of the commission and its growth and development. As you know, this kind of event doesn't happen just because it magically happens. It takes a lot of people, and I want to just take a moment to acknowledge them at this time. So first, I want to acknowledge Cynthia Delastrinos, the court manager for Supreme Court commissions. When we were faced with staffing challenges, she just stepped right in and made it completely seamless. So wherever Cynthia is, thank you, Cynthia. I want to thank the Temple staff, especially Guy Rosser, Tyler Williamson, Rob Mead, and the entire law library staff, especially Ellie Krumwede, who really is a wonderful liaison to the Minority and Justice Commission, my judicial assistant, Jessica Gonzalez, and my extern, Beverly Sy, who was also an SU Law student liaison to the commission. Special thanks to TVW and their staff for covering this event. They were here very late yesterday, making sure that the connections for streaming and viewing would go perfect today. I also want to thank Steve Crandall from Pro Lumina, who every year donates their time and their equipment because of their personal belief in our motion of promoting fairness. And then finally, I want to acknowledge our remote sites. We have people gathering in Spokane at Gonzaga School of Law, and Minority and Justice Commissioner Teresa Cronin worked very hard to secure sponsors and space for such a viewing. Those are the sponsors of the Spokane event. And then we also have people gathering at the University of Washington School of Law. We have our Minority and Justice Commissioner Lisa Castilleja and their UW student liaisons who are hosting and viewing from that remote site. So now I will turn this over to Minority and Justice Commission co-chair Judge Helen Whitener from the Pierce County Superior Court. Again, thank you, Justices.
Thank you, Mary.
Thank you, Justice Yu. May it please the Court, Madam Chief Justice, Justices of our Supreme Court, and ladies and gentlemen. Welcome to this year's Minority and Justice Symposium on Artificial Intelligence. Washington State has a diverse population, and in recent years we have seen within our state and nationwide an escalation in the use of surveillance techniques enhanced by modern technology. We have gone from paper record keeping to computerized data collection, from physical surveillance to surveillance cameras, facial recognition software, and even automatic license plate recognition systems. Many of the advancements have outpaced our laws. An inordinate amount of personal data is collected and stored in databases that are routinely accessed and shared amongst law enforcement agencies and private entities, many times without legal oversight. Courts have always endorsed reasonable use of technological advancements that increase efficiency, decrease costs, and promote timely and even-handed administration of justice. However, due to systemic, structural, institutional, and economic discrimination present within our justice system, the potential for misuse of these great scientific and technological advancements have placed our weakest and most vulnerable citizens at risk. Overuse of these surveillance tools have resulted in racial profiling, targeting of unpopular minorities without particularized suspicion of criminal wrongdoing, targeting groups of individuals because of their religious beliefs, targeting groups of individuals because of perceived immigration status, and targeting of groups with a lower socioeconomic status. As we learn and try to address the legal challenges to the advancing frontier of artificial intelligence, let us remember that the judiciary has always been the branch of government that has protected the rights of the minority from majority rule. As our Chief Justice, Mary Fairhurst, has stated, the fundamental mission of our courts is to ensure due process and access to justice for everyone. We must ensure that all who seek justice within our courts find it. Thank you, and we hope you enjoy the rest of our presentation.
Thank you very much, Judge Whiteman. And thank you for co-chairing our Minority and Justice Commission. We're honored to have you in that position. Good morning.
Good morning, Madam Chief Justice, honorable justices, folks in the room, and those watching on TVW. My apologies, first of all, for having my back to you. The charge for RC, my co-presenter, and I in putting this presentation together for you this morning is really to set the table, I think, to provide us all a common language around the basics of how AI works and some of the policy and technical issues that have been raised around it. Our intent will be that that framework will be useful for you during the rest of the day. Just to give you a little bit of background on who's talking to you, my own background is as initially a technology lawyer. In fact, in 2001, up in Seattle, I started practicing. I worked for Microsoft and for Amazon and for a number of the other tech vendors, and then moved into being an advocate around civil liberties, particularly lifting the voices of communities that haven't often been a part of the technology conversation. RC,
And Ryan, may I interrupt you for 1 second? We have turned the microphones up as loud as they can go, but we have a very full room, and we also have air and outside noise that's impacting. So that to the extent you and the other speakers can speak louder but comfortably, it would help us because we want to be sure we hear every word.
I will be happy to project.
Thank you. Yes, you could use your outside voice inside. That would be great.
I will do that. So RC and I obviously come from different perspectives. I will say we don't agree on everything, but we certainly have a significant locus of agreement. And I think chief in that space is this idea that technology should be driven by our values. Technology should not drive our values. and that values really need to be part and parcel of the way that we adopt technology into our society. So hopefully between our two perspectives, you will be able to take away this diverse set of considerations as to how you think and understand AI. For those of you who are more technologically sophisticated, I apologize if some of this is basic.
I think it's important to begin with basic.
I think so. Can we? Thank you very much. So our agenda for the morning is as follows. We're going to... Oh, that is interesting. Hold on. There is a number one. Okay, there we go. Okay, we are going to start with some framing ideas that I will present around AI and how to understand it. For RC's part, he will provide us with, a technical perspective on how AI works using the ImageNet example. We'll flip back to me for looking at this question of bias, which has been hot in the news, as I'm sure you folks in this room are well aware, what it means in the context of AI. Another deeper dive into the one specific example, which is the Compass risk assessment tool. A scan back to AI and equity. A very quick look at some of the policy issues that both legislators, regulators, and courts are considering around AI. And then we will do some Q&A. And we're going to try to wrap up to have sufficient time for that Q&A. So I want to begin with a simple breakdown of I think, how a layperson can understand the choices inherent in AI. My first proposition to all of you is this idea, an important one, I think, that technology is not neutral. There's often a perception that there's some perfect way to build a given technology, but that's actually never been the case. In fact, far before AI ever showed up, in 1980, I think there was a gentleman by the name of Langdon Winner who wrote an article, Do Artifacts Have Politics? And he actually discussed at length this idea of every kind of technology having its own politics. One example was overpasses. At some point, the decision was taken to build overpasses lower than they previously had been. This had the effect of not allowing buses to pass under the overpasses. It privileged cars and drivers, and therefore suburban outskirts over urban cores where bus transportation and bus users were more common, car owners were less common. And that idea actually really does transfer to AI. Every AI-based technology involves choices. For example, what data do you include or not include in a given tool? If you are building a recidivism algorithm, first you have to look at what data sets exist out there, right? Is relevant data even being collected? Are those data sets, quote unquote, clean enough? And as we'll see down this presentation, there are questions about what kinds of bias may be embedded in given data sets. Are the data sets that exist close enough to the populations that the tool is actually going to be making decisions about? What's in and what's out, right? At some point, you have to make a decision about what data sets will be considered in a tool, and how heavily do you weight those data sets? What are you really solving for? And of course, in addition to the values that are built into the technology itself, there's a whole complex ecosystem that a technology tool is released into in the world. This is a world in which tools interact with humans who have political incentives, and of course, social science documented tendencies, for example, to overtrust algorithms because they're considered science. And of course, a world in which inequitable existing systems may lead to disproportionate impacts, which is a point that I will emphasize in this in this presentation as well. There's a whole science called HCI, human-computer interaction, that also documents those kinds of impacts, and they can occur regardless of the intent of the designers of the tool. Another proposition, and this is really just the few basic steps that get us to the creation of AI. Basic step number one, to live in our current society, we all shed data virtually everywhere we go. We have phones, they have literally hundreds of apps on them. I don't know about you, but I certainly didn't read the terms of service on all of those apps before I clicked through them, and they are collecting data. Websites we do business with just to live our lives also likely collect data. Moving around in public, your license plate gets scanned, your ORCA card gets scanned. Various kinds of surveillance from public and private camera systems and other surveillance mechanisms. This is all data that feeds into artificial intelligence systems. That's the data that the AI, quote unquote, learns. And I think the scale and speed at which algorithms are being adopted in the public and private sector would likely surprise a lot of people, even people who think that they have an appreciation of the scale and speed at which that's happening. And I count myself among those people. I get paid to look at the impact of technology on society, and the new use cases that come up virtually every day never cease to amaze me. I think there's often a disconnect because it's, I think, more the exception than the rule that the algorithm that either partly or wholly makes a decision is even disclosed to the people about whom that algorithm is making a decision. So, for example, when someone is denied a public benefit on the basis partly of an automated system, that may actually never be disclosed to the person. Their check may simply be reduced without explanation. And finally, where this data goes into AI systems, but what are those AI systems doing? I want to just for the sake of basics, explain a few terms and then turn it over to RC for a more technical explanation of AI. One idea is just aggregation, which simply means that there is more data that talks to other data in one place than there used to be. If I attended a protest back in the day in Seattle and one in Tacoma, I would have a dossier in Seattle and a dossier in Tacoma in a filing cabinet, perhaps, in each police agency. But those dossiers would rarely, if ever, actually meet. And yet now, police agencies, for example, are investing in systems, third-party systems, that are explicitly designed to break down those silos and to ensure not only that that data talks to the other data, but that analytics can be applied to it. Analytics is simply the science of what inferences we can derive from a given data set. And the important thing, I think, to understand about analytics is that that science is always advancing, all right? So we can pull more inferences out over a period of time from that same data set because the science gets better. And that's one reason, for example, why anonymizing a data set is always only a temporary thing, right? In other words, disassociating a given piece of data from the person that data is associated with, anonymizing, can perhaps eventually be defeated because there's more data out there and that data allows more inferences to be drawn. So in the future, that anonymized data may be able to be re-identified. Machine learning is often a term, I think, that's used interchangeably with AI, but it's actually, I think, a subset of AI. Essentially, the way I like to explain it is it's an algorithm that alters itself based on the data that is fed into it. Right? So the very decision-making basis of the algorithm changes based on the data that goes in. This has some corollaries as well. I think one thing that it means is that at some point, even the creator of a machine learning system will be unable to tell you how it's making decisions. They program it in a certain way on day 1, but on day 5, it's ingested data, it's making decisions differently, and on day 50, differently yet. So this explains, for example, why the celebrated example of the Tay chatbot that ingested racist invective from the internet and spewed it back at people that were trying to have a nice chat with the bot. It also has significant implications, I think, for the value of deleting data sets. If you feed a data set into a machine learning tool and then delete the data set, can you be said to have deleted it if it lives in the way the algorithm is making decisions? On top of that, there is predictive analytics. My clicker is buzzing. Predictive analytics are tools that are designed to tell us, based on this kind of machine learning analysis, what actually might happen in the future. Is this parent likely to abuse their child based on data fed into the system about many other parents who actually did or did not abuse their children? Is this individual a flight risk based on data fed into the system about many other individuals who did or did not flee? Two very specific highlights about this idea I'd like to put in front of you. One is the old adage that correlation is not causation. And I think that's one to come back to again and again when looking at AI. The data may highlight factors that correlate with child abuse, but it does not necessarily mean that those factors actually cause someone to abuse a child. In some ways, these tools are inherent double-edged swords. They are often cheaper than the equivalent individualized human-based assessment. For example, a caseworker calling up a family to go through a checklist of actual causative risk factors to determine the risk of child abuse in that family. That makes them attractive to government entities. But of course, they essentially operate by putting individuals in fixed buckets, right? You'll be a 1, 2, 3, 4, or 5, say, on your risk scale, which means individuals may be misclassified simply because some data suggests that they share something in common with people who actually are abusers. So with that, we'll move to the technical side, and I will turn it over to RC.
Thank you very much.
Good morning,
Welcome.
Justices. Good morning, ladies and gentlemen. Thank you so much for having me here today. I'm excited to talk about AI. I think in putting things in context, I'm just a couple of steps ahead of you. So I'm only going to say, while we have Q&A set aside at the end, since this is supposed to be technical, and I encourage you to ask questions along the way, if you feel free. And before I begin, I should say I need to do a special shout out to the Minority and Justice Commission. I've been working with them for a year or two on the LFO calculator, Judge Linda Coburn and Cynthia, and it's something we're hugely proud of. I want to say the team has been incredibly impressed with Judge Coburn, and we hope that it's a tool that you find useful. I know the team was very excited about working on it, and so it was a pleasure and a privilege for me to basically turn Judge Coburn loose. She has been an amazing force generating this, and it's really been incredible to see her translating her knowledge into that application, and I hope you find it to be a useful
Please
tool.
don't try and steal her.
No, I thought about it. I said, but no, then she's better than me, so I don't want her. So I'm going to talk about AI, and I'm not going to talk about how AI works. I'm going to use an example of image recognition, but I think what's important, I think, is giving a framework for thinking about how AI works and the way we produce it from an engineering perspective. And so I'm going to talk about, so this says, how does AI work? Let's start with a neuron. I'm going to say with how I think about AI. When you think, there's a school of thought of cognition that says the brain, the body is just a way for the brain to express its intent. And so how does the brain express its intent? It expresses its intent in a bunch of different ways. One of the ways we do it is pattern recognition. One of the ways we do it is navigating around the world, just being able to identify ourselves in 3D space and being able to move across that. That's an analog for robotics. When we think about, we communicate with folks, we talk. One of the big things of AI is text to speech, speech to text, taking that communication interface and doing what normally happens in your brain to an external actor that's simulating it. It's simulating it with a model. So the model is saying, this is how I think your brain works, and we're using it to basically apply algorithms to kind of mimic your thinking. And so it's a model, it's an approximation. It's an approximation of the world. It works insofar as it works, but we have to be careful how it's not working. So when we talk about artificial intelligence, a good subset of that deals with this notion of neural networks and the notion of the neuron. And so why do we care about the neuron? From a cognition perspective, obviously it helps us think, but from an engineering perspective, it's the engine that helps us run the functions, right? So when we talk about the functions, it's the signal processor, inputs and outputs. It takes inputs such as senses, inputs such as text, and then processes outputs. It gives a determination of what that thing means. And so that's why we like the neuron, because it's a signal processor. It has an activation function. When we think of an activation function, nonlinear, I'm going to take the next two. Those look like big terms, but I'm going to put it in a very simple term. When I reach and I touch a flame, that's an activation function. My body is saying, hey, the sensors that have said you're not supposed to be on fire, they're saying you're on fire. That's a pretty strong, nonlinear response. It's like, get your finger off the stove. That's a kind of very aggressive, we have this thing called stochastic gradient. It's a very punctuated signal that says this thing is true, take action. So that's why we like neurons from an engineering perspective. And also, this single neuron can take a bunch of inputs. So all those inputs, it can say, like, I'm going to take all my skin sensors and say, are they on fire? And that input, I can scale to that. So that neuron can make a decision about me being on fire. And that's important. And so that's what we like. We can link a bunch of them together and create a network. And that network can do all kinds of cognition for us. And so the way we string them together, these are all different ways of stringing together those neurons. And, I'm going to talk about deep convolutional network. We're going to talk about that today because that's what's used in image recognition. And then we can, if we want, we can talk about generative and adversarial networks, so ways of fighting image recognition and surveillance. But that's the neural network type that we're going to talk about it, and we're going to talk about it in the context of image recognition. So I don't know if you guys remember, this is one of those scary AI moments when machines can see better than humans. Machines can identify objects better than humans. This ImageNet conference is where that alert that we're all doomed came from. Like, computers are going to be better than us. And so it's a competition called ImageNet. And what ImageNet does, it uses image recognition. It basically tests different teams and their ability to recognize what's in different photographs. And so there's three core components to image recognition. Object detection. What is the thing in the scene? What are the things? And then you have to classify those things. You have to give them a name. You have to categorize them. And then there's a notion of object isolation or segmentation. In this diagram, it's the big square bounding box, but it's the ability to identify the thing and isolate that thing from its surrounding environment. So when we talk about image recognition, that's the kind of proxy, that's the contest that we're trying to measure. So the ImageNet challenge was really a hugely transformative event because it pitted a bunch of different university and professional teams against each other to see who could identify a set of 1,000 test images the best. And it was 6 years of competition. So when we say image recognition accuracy increased from 71.8% to 97%, that means if you showed a computer an image, it would be correct 97% of the time in identifying what was in that image. Human capability is right in that 97%. So if you look at 2015, there's a bunch of little clusters of dots. That's when we pass that human perception boundary. And so what was interesting, though, is if you look at 2012, there's a little dot way down the bottom. Those are the results of the teams, and that's a 40% improvement on the competitors. That was a breakthrough that occurred in 2012. That breakthrough was the use of a deep convolutional network by Jeffrey Hinton. And it was an incredible effort. And the reason it was incredible, and the reason I use it as an example, is because it's expanded, it was hugely performant. It was twice as good as the next competitor, but, oh, this didn't come out very well, I apologize. It was actually a model purpose-built for a lot of the capabilities we have today. When we talk about the cloud and we talk about these GPUs in the cloud, we're really talking about video game engines. We're talking about video game processors. So the same thing that's doing Halo and Fortnite, those are the GPU processors you have doing this AI. And the reason that you use those is because they're very optimized, obviously, for rendering polygons. Well, for image recognition, a lot of the tasks you're doing are polygon-based. So you have the ability to train this network on video game processors. They did this, they changed it up in 2 days, and they basically used 2 interactive networks. They built that over 3 days. So think of that, that's your AI engine ready to process your data. But the other thing they did that was really powerful, they used ImageNet itself to train the data. And that's hugely important. If you ask them, the authors of that program, what's the thing that allows their system to succeed, it is the data and the GPU. That's the only thing that's limiting them from making this model better. The algorithms have been around for a long time.
Can you say what GPU is?
Oh, graphics processor unit.
Thank you.
So just like a microprocessor has the CPU, central processing unit, they usually have a GPU associated with it. It's strictly for painting the screen, painting your pixels on your screen. And so when you think about that, let's talk about ImageNet. So ImageNet, the thing the contest was based on, they actually trained their model on ImageNet itself. That was the key there. They trained their model. And ImageNet, if you talk about ImageNet, it was basically a huge data repository, right? It's something that was collected. 15 million images was collected by this team. It was actually one of the largest data gathering efforts ever on Amazon's Mechanical Turk. I don't know if you know that, but that's a way of doing piecework. It's a way of doing digital piecework. And so they had 256,000 people hand categorizing images to create this data set. And they're doing it in a particular way. So this is called a SynSet. You know, this database, which I love, has 62,000 images of cats. Okay, so this is the SynSet, the synthetic data set of the Persian cat. So there's how many images of Persian cats? 1,600 images of Persian cats. And so that device trained their model on the entire corpus of data there. Previously, they didn't. They trained it on a subset of images because they thought the strength was in the algorithm. No, the strength is in the data. That's what's key here. And if you think about this, so this is a very simple, right? So this is a very simple, in some respects, data model. Because it's a million images of things to data. Now think about the images for other systems, like Shankar was talking about. You're moving about data in space. You're moving about in space and time. Like that data. Who's collecting that data? So when you think about data, that was a huge effort. It cost hundreds of thousands of dollars, coordinated effort. Think about the data of other things making decisions for us, because that's the key. So when we think about AI, we have to think about data. And when we think about that, we have to think about what's in that data. Are people in that data? How do people feel about being in that data? Is that data representative of the population it's trying to serve? That's a big deal. I mean, you saw the amount of work that goes to get into the ImageNet database. Now think about something that's going to be reliant on facial recognition. Because when you think about facial recognition and things like data-rich data sets, what you realize is that the diversity of imagery that you have to collect to make determinations on, you need a lot of images to train and understand. And so thinking about how you even train the models, never mind what the models are being trained on, is a very significant challenge.
RC, could I ask you a question on that?
Certainly.
So we heard it, based on the ImageNet research, how do we know what the machine is seeing? So they gave an example of like determining or identifying a difference between wolves and huskies.
Yes.
And it turned out the machine was seeing snow because all the pictures of wolves
That's very true.
had snow. And so you just show it a picture of snow and it would say wolf. So the fallibility of that, I just wonder how we identify what it's actually seeing in the data set.
Well, and I think that's fair. In this case, that's a really great point, because at least in this case, you actually have a supervised learning data set. You can actually, someone can make the determination that that is a wolf or a thing. And how the machine learns that that is a snow wolf, you're absolutely right. That's one of the, when people talk about the hidden data, Like, how is the machine making determinations? And when you think about it, I think particularly in the case of something like handwriting recognition, where you don't have supervised learning. So this is a case of supervised learning, but it's very clear what the determination of the image is. It's a gibbon, or it's a wolf, or it's a coyote. And so, but for the case of handwriting recognition, we'll say, like, we'll just feed samples of handwriting, and the machine says, it says this thingy maps to this thingy, not we know this is an S and this is an S. It's just generating its own information. It's that lack of transparency, that lack of understanding how the cognition is being done that matters. That's the challenge. And I think that concludes my section.
So my takeaway from your presentation is that those of us whose kids grew up doing first-person shooter games like Halo or GTA were actually engaging in good parenting rather than bad parenting.
Exactly right. I have a dad joke about supervised learning. It's called when mom goes away and dad's left taking care of the kids. From the kid's perspective, is that supervised or unsupervised learning? I don't know.
And how much parents you ask.
So in my previous enthusiasm to jump into the presentation, I realized I was remiss in not thanking the Minority and Justice Commission, and particularly Justice Yu, who has worked tirelessly to put this morning together. I think for us in Washington in particular, it's very befitting our status both as a technology leader, but also as a place where we have worked to put safeguards around technology, and there are numerous examples of that, both locally in the legislature and here from this court. So thank you, Justice Yu, and thank you, Cynthia, as well, for all your work in putting this together. So one of the charges that RC and I had that we wanted to make sure to drill down on is this question of bias, because again, it's part of the framing of this entire conversation. One of the ways that I have done my work in this space is by engaging with voices that are not often brought into the conversation around technology. In other words, communities that have a history of being disproportionately impacted, not just by AI, but by a whole string of technologies preceding it. So I'd like to start with a couple of quotes from people who are currently doing important work in this space. This quote is from Malkia Cyril, who's actually at the Center for Media Justice. I think the point of this is to highlight that although AI technologies themselves are relatively new, it's long been the case that virtually every technology has a differential impact depending on the power structure it's released into, which of course systematically advantages some and not others. And what we seem to be finding more and more is that it's very difficult for technologies, even those designed with good intent, to avoid replicating or even sometimes amplifying those disproportionate impacts, and that is what I will speak about in this section. Another great quote, this one from a local leader in the Japanese American community, referencing a quote that he had heard from a survivor of the Japanese incarceration. I think one thing that's less well known about that sordid chapter in our history is that that incarceration was undergirded by a registration system and census data. In other words, the data technologies of the day that made it very, very difficult for individuals in that position to avoid being incarcerated. They knew exactly where to find them. And both Malkia and Stan talk about the 20th century being a long history of use of powerful surveillance technologies that had impacts on particular communities, whether it was black civil rights leaders who all had dossiers, including Larry Gossett here in Washington State, to labor leaders, to post 9/11 warrantless, suspicionless surveillance programs on the Muslim community in New York City, using technologies like license plate readers and cameras. A program that was later struck down as being illegal for a number of constitutional reasons. But I think the point that's often made by that community is the safeguards actually didn't prevent the surveillance from happening, the illegal surveillance from happening. It happened, was struck down after the fact. But I think the lesson learned for some of those folks is that it's important to create the frameworks to prevent the harm from happening at all, rather than rely on the courts as a backstop. So with that, let's get into a discussion of bias. Unfortunately, I get paid to read far too many studies about bias, and I have really tried to resist the temptation to make this a technical discussion. What I want to say is that bias has literally dozens of definitions in this space. If you're all ever in your chambers with 20 minutes to spare, there's a great video by Professor Arvind Narayanan of Princeton, who's a data scientist in the space, who discusses 21 definitions of fairness and bias. Many papers on this subject. And I've tried to provide, I think, a brief sort of taxonomy, not just of bias, but I think of a broader concept. Because I think one thing to understand is it may be less helpful to focus narrowly on what bias is, and instead to consider the ways in which AI tools are built and how the choices that go into AI tools being built impact individuals and communities. In other words, who wins and who loses based on a particular way of designing a tool. And the first issue in terms of the trajectory of a tool really starts at the very beginning. What problem is the tool being designed to solve? A good example is interventions-based models versus risk-based models. There has been a back and forth swing over the decades in the criminal justice system between risk-based models, which essentially assess an individual's likelihood of recidivism, versus interventions-based models that use data to determine what interventions will give that individual the best chance of not recidivating. In other words, one is static and one is dynamic, but building those tools are very different exercises that have very different results and very different impacts on the people in the system. Another good example is physiognomy and facial recognition or face surveillance. We have tools now that purport to determine your propensity to be a terrorist based on an analysis simply of your face. These are tools on the market right now. In the social science, we moved away a very long time ago from physiognomically based models that purported to determine, for example, someone's intelligence. But because this is being marketed as data and science, that element has returned to the conversation in what I would argue is a dangerous way. So framing the question is really the first step at which bias can enter. We're going in a very different order. Okay, there we go. So then there's the design of the tool itself. As I mentioned earlier, someone has to determine what attributes are in and what attributes are out. And it becomes very complicated when some of these data sets are not representative of the populations impacted and may, for example, correlate with race or gender in undesirable ways. You say, well, why don't we just get rid of those particular tainted data sets? It turns out that it's really not that simple. There are studies, for example, that show that even if you make systematic efforts to remove those data sets that are correlated in that way, you may still not succeed at coming up with a tool that does not have those systematic biases. This can be extremely complicated. And of course, then there's the garbage in, garbage out problem that the data used to train AI technologies can reflect existing biases. The most celebrated example of that, I think, is just historic crime data, or somewhat other measures which may be general neighborhood disorderliness, right, which are often correlated with race in ways that bias the tool in an undesirable way. And then finally, of course, the implementation where a tool is deployed within an existing structure. In the example of facial recognition, that it's well documented that there are neighborhoods that just have more cameras in them. They're historically over-surveilled. And releasing a facial recognition tool in that context, of course, means that you're using facial recognition disproportionately on those communities. If that algorithm is, for example, using booking photographs as its comparison database, another potential layer of bias is incorporated because of the historic disproportionality in arrests. So these are challenges for that must be grappled with, because of course there's no neutral way to build these tools. Just a few examples here, and I won't dive very deep because, of course, that's what the rest of the day is for. But certainly predictive policing, this is one you may have heard of, where a good summation of what's been found so far is that it's often more reflective of where we look for crime than where crime is going to occur. This was among others, the Predpol tool that was the subject of a study. Facial recognition has fairly well documented challenges in identifying people of color, women, transgender individuals, and others. I think what's less well known is that facial recognition also has similar challenges, not just for identification, but also for affect recognition. In other words, determining who is happy versus angry, for example. A recent study showed NBA basketball players on whose photographs this tool was used, and in this instance, what they found was the African American basketball players were had a much higher likelihood of being shown to be angry rather than happy, even if they were visibly smiling, and a human being could simply tell by looking at the photograph that both of these people are smiling, versus the white basketball player who had a higher incidence of smiling versus anger. DNA predictive algorithms, which purport to determine the likelihood of an individual's DNA being part of a mixed or corrupted sample, which is coming up more and more frequently, is hotly disputed. Experts will come in and argue that the same tool has orders of magnitude difference in its efficacy in being able to identify an individual, well, not identify an individual, but the likelihood of an individual being a part of the sample. That leaves the courts obviously in a very challenged position of having to rely on dueling banjo experts to figure out how to account for or discount the findings of this tool. And then, of course, child welfare predictive algorithms, I've already flagged that, may disproportionately flag poor families or parents of color. Just a few examples from a fairly vast universe. But again, undergirding this point that there's no single scientific way to build these tools, and it's always worthwhile to be skeptical and ask for the evidence and examine it. And the last slide of this section is really my way of emphasizing this idea that notions of fairness involve inherent trade-offs. The predictive accuracy of the tool overall is a different thing than, for example, what's called predictive parity, which, in the case of a recidivism algorithm, simply means that the tool identifies, every high-risk offender that the tool identifies has the same risk of recidivism regardless of their race. All right? That's predictive parity. However, because we also have group distribution influenced by existing structural inequity, that definition of fairness will lead to disproportionate outcomes, as we're about to see in our deep dive into the Compass example. More data isn't always the solution, simply because more data can be impossible to find. Clean data sets can be impossible to find. And finally, we don't really have the mechanisms yet by which we can put tools on hold even when bias is found. It's very rarely the case, if ever, that once a bias study goes out, of which there are so many now, that that the manufacturer says, wait a minute, time out, we're not going to sell this until we fix it. So we are living in a space where imperfect tools are out in the world. Some have called it a massive human experiment, to which, if a university was doing it, a lot of ethical standards would apply, but because it's simply being bought and sold in the marketplace, those safeguards aren't there. So with that, I will turn it over to RC to start us off on Compass.
Hi again. So I'm not going to do a deep dive. I think a lot of you actually on this panel know this story better than I do. So what I'd like to do is talk about Compass in the context of a practitioner, how I look at it as a product manager saying, I want to build a product. If I were to do a teardown, one of my favorite sites is this, the CBN sites. They do these teardowns of company. What's their business model? How are they succeeding? So this is kind of I want to do a mini teardown of the Compass project and how I look at it as a practitioner, as a product manager. So as you know, Compass is a tool that provides decision support. This is from their user manual. Decision support for correctional agencies for placement decisions, offender management, and treatment planning. It's basically on a questionnaire folks fill out. So from my perspective, trying to figure out how to talk about Compass, I can say one of my biggest concerns from the very beginning, which is an inherent conflict challenge in the space today, is that it's proprietary methodology. It's a black box to us. We don't know how it's making its decisions. To your point, how is it determining Gibbon versus Coyote? We don't know. In fact, in the context of some AI technologies, they're not designed to do that. They couldn't tell you if you asked them. They'd have to come up with a way of saying that. So in the case of robotics, they could say, like, how did I reach that decision? They'd have to kind of go back and say, think about how I reached that decision. They're actually rationalizing how they made that decision because they don't know themselves. So if you think about that, that's profound. So in this case, we don't.
Can you tell me what Compass is? COMPAS?
What it stands for?
Yeah, I don't.
That's a great question. Does anybody know what it stands for? It's a.
I'm not familiar with it.
Oh, it's a correctional. So it's used for predicting for recidivism decisions. So organizations would use it for making this sort of determination whether someone goes on parole or not, how long the parole is. So when they think about it, they use it in, as they say it, placement decisions, offender management, and treatment planning. So that in and of itself, I'm just going to say that right now, that's a lot of objective functions to solve for. Those are different questions, and yet we have one model to come up with that. And we don't know how that model's making those decisions. Like the way we're figuring out how well Compass is performing in its structures, they're black box studies. They're done based on comparison of outcomes. You still don't know how it made those decisions.
Isn't that the same thing with human decision makers?
True.
If the results are that they're disproportionate in their decisions, we don't then often fire the decision maker. We'd be getting rid of a lot of judges in the state if we did.
That's right. That's right. Well, I mean, that's the funny thing. When you think about how the computer's making decisions, you think about how we're making decisions. And I think if you read Thinking Fast and Slow by Daniel Kahneman, who talks about how we make all the ways we interpret bias, like Shankar's absolutely right. There's a new bias every day. Ask me about emoji bias. That's a thing. Emoji bias manifests in different devices differently. The smile on an Apple iOS device is different than a smiley emoji on an Android device. Users respond via user studies to the smile on the Apple device as a grimace. They're less happy as a result of seeing that emoji bias.
Justice Gordon-MacLeod, just to respond to the question, Compass is actually, it's a tool used in most correctional institutions to make some determination of release, probation, a variety of decisions about somebody's risk.
Thank you.
That's right. Thank you. And that's the key point. It's making a variety of decisions based on one outcome. And so when we talk about that, so I'm going to show, so the question here, right? So there are 137 questions they ask. Technically, they're not supposed to ask questions about race. They can't actually explicitly ask questions about your background. But if you look at the questions that they ask about things that could easily identify proxies for race. So it's almost like a straight short circuit. They don't have to ask whether you're African American or not. They can infer it directly statistically, the same way that snow is associated with the coyote. The external data that you're capturing provides a direct analog that you can make an assumption against, and that's part of what's going on there. And of course, the data sources and the weightings are subject to bias. When you think about, from that instruction manual, they will tell you in a 2012 instruction manual that the original data set was from 2004 to 2008 across the U.S. By definition, you're going to have data bias in that structure. We think about taking that from a training set that is 30,000 respondents across the U.S. and you're plopping it down into Broward County, Florida, you're going to have different data dynamics going on, different ways of collecting data, different weightings of the data that's being collected, to Shankar's point. Maybe there is more surveillance there. There are more community policing activities there. Whatever is happening in that place is going to distort the results of what's happening in the questions that are being asked by the folks. And we don't know, because we can't see that algorithm, what's going on, why it's making that.
About that lack of transparency piece, how much of that, so you say it's proprietary, but it's unclear to me at what level and why. Because clearly, I mean, of Judge, we've for years been trying to create checklists or whatever, but at least the questions the judge must go through, albeit biased, are known.
That's a
One
fair
can make
question.
a public records request and get the checklist.
Well, the determinations, so sometimes there have been instances where the determination has been because the algorithm told me to.
Right.
And that's been acceptable because there isn't a way to point to another thing that is better than that. When I think about things of saying if you can think about a way like what's the best way to do it, there isn't necessarily a best way to do it. So from a litigation perspective, you can't say do it this way because you don't know what the best way is. And so right now the core privacy shield is competitive IP. That is their intellectual property is wrapped up in that algorithm. And so to reveal that is to compromise their commercial potential for that.
RC, there's just been a request if you could speak up and slow down.
I'm sorry, that's one of my bad habits. I apologize. So yes, so when we think about, so did I answer your question? I want to make sure.
Well, not entirely. This is what I guess I don't understand about what the intellectual property protection is.
The algorithm
It's hard for me
itself.
to believe that the data set is like patentable. I can see that
Right.
the program might be, but that's what's baffling.
It's a really interesting question because when the state takes on ownership of this software, does it own the data? Who owns the data? What is the license agreement it's signing? And that's an interesting question. Can the state manage that data? What is it using as its inputs to the data? How does the state taking over this, or the organization that's running it? So I think those are very valid questions. I don't think they've been answered yet. Okay. And I think that this is the question that Shankar is getting to. I mean, whatever you say about Compass, it's yielding decisions based on a series of parameters that are being put forth. The real question is, what are we asking it to do? What is the definition? What are we asking it to optimize for? To Shankar's point, this algorithm, when North Point, or now there's another company that owns it, advocates in public for this, they talk about that 61.8% across race normed. The level of recidivism is neutral to race based on this one statistic, like the percentage of recidivism, like 61.8% and 62.3% for the different communities. But the challenge is, because you have two different populations with two different sizes and you're trying to norm them to the same outcome, just by that, squeezing them to the same outcome, you're going to push out answers and make other answers have to respond to that. And how that manifests, and this is where the bad thing is. So Brisha Borden who basically took a stroller from a toy store, got yielded as a high-risk 8. That's a high-risk determination. This other person, Vernon, who was a notorious thief, got rated a 3. In and of itself, that's whatever. That's just a number. But it's the outcome that what happened as a result. Because of that 8, Brisha Borden faced a lot of other challenges in terms of the sentences she faced and the fines she incurred because of that rating. So it wasn't just about the rating that she said, whether she was likely to recommit a crime or not. It's what the municipality does with that decision. And I think that's when we talk about the outcomes, when we think about that's the challenge. Like, is that the outcome we seek? Because the outcome North Point sought was to have everybody have the same recidivism rate across populations. That's fine. But if we're making determinations, maybe there might be other optimizations we seek. And that's fundamentally the core that we're trying to make. Sorry. Does that make sense? And then, it'd be both, since I was going to take the technical, I want to turn this over to Shankar to talk about what's happened with the legal perspective with the same kind of technology in Wisconsin.
Thank you. I realize that we may have simply assumed that this was a celebrated enough case that that you all would be familiar with it. But this was an instance, I think, in which there was a fair amount of public controversy. I believe we included in your packet an article about from ProPublica, basically making the exact same critique that RC just outlined about the disproportionate impact, and that resulted in North Point coming back and saying, no, wait a minute, based on predictive parity, our tool is fair. And a fair amount of jostling took place after that, which is well documented, and I'd encourage anyone in the audience and all of you as well, if you're interested in digging in. There is a lot of literature on this particular instance. I did want to pick up on a couple of points before I get into this case. One is this question of humans versus algorithms, aren't we simply talking about two biased entities rather than algorithmic bias versus perfect humans? And that is absolutely correct. We are. I do think that a few points bear repeating, which is one of which is that human bias tends to be multidirectional. Whereas algorithmic bias, you're replacing the multidirectional biases of a whole lot of judges with the unidirectional bias of a single system that is supposed to inform the discretion of all of those judges. But as we'll see in practice, perhaps may end up replacing it. And of course, this question that I think was being got at here about how hard it is to challenge, how transparent that bias is, where you can see the questionnaire that a judge may use. It's often very difficult because of trade secret and non-disclosure agreements to examine the black box of these tools, which is why I think we now have calls for particularly entities selling tools to public agencies to actually waive trade secret protections, to not be allowed to put these very restrictive NDAs into their sales contracts. And also calls, on the litigation side to redefine trade secret in the context of algorithms to perhaps remove some of those protections in particular instances. But Compass will be of interest to all of you because this was, of course, the state Supreme Court that took on these issues in an instance of gentleman Eric Loomis being sentenced in part on the basis of a determination made via Compass. It's an instructive case. The court upheld the use of Compass despite the various issues that were raised. Among the interesting findings of the court, I think, were the fact that they said the use of gender as a factor in this risk assessment served the non-discriminatory purpose of promoting accuracy. Right, so the court never actually explained why they thought accuracy was the paramount value or the thing that equated to fairness in this instance. They simply upheld the use of gender as something that promoted accuracy and therefore, in this instance, was non-discriminatory. And they also said, by the way, that Loomis hadn't provided sufficient evidence that the sentencing court actually did consider gender. So that was interesting. In some ways, the case sort of turns on both the availability of the data to the public and also this human-computer interaction question and how much agency you believe humans have in these kinds of decisions. The court, one of the things the court said was that because Compass uses publicly available data that could have been challenged by Loomis at the trial court, that made the use of the tool more acceptable. Of course, not necessarily accounting for this being very difficult to challenge because there was no way to know which data actually mattered the most in the way the tool worked. The court did say that the algorithm pushes against individualized sentencing by grouping in the defendant with, a group of individuals, but said that the determination was still sufficiently individualized because the court had the discretion and the information needed to disagree with the assessment. What the court said, what they prescribed was that judges must essentially read 5 warnings about the proprietary nature of Compass, the fact that it's not locally validated, it relies on national and not local data, that it relies on group and not individual data, that studies have shown it to be biased, and that it was actually developed for use in a totally different context, which is post-sentencing determinations. So judges were supposed to look at all of those things and determine how much weight to give the tool. And you can already see the problems with that, right? The decision was criticized in many corners. Critics basically said, there's no way for judges to know how much to discount this tool because so little is known about how it works. Hard for judges to understand the problems, the systematic problems with algorithmic risk assessments. And of course, the fair body of evidence that exists, both psychological and sociological, showing that people tend to defer to expert empirical assessments and also to have this, what's called anchoring bias, which is essentially you get a piece of information and you tend to account for it in your later decisions, even if you don't know that you're doing that. So a raft of issues in that Compass instance.
Ryan, may I ask a question?
Yes.
I'll try to speak loudly also. Have there been any studies or review after the fact of courts that use Compass to see what numbers were attributed to the different defendants and in retrospect could see that in fact it reflects what this did? I mean, of course, I haven't read what's behind tab 2 yet, but the question is, could an argument be made? You have to come back now to try to challenge it, and it's very difficult in a case-by-case basis. But if a university or someone were to empirically say, okay, this county uses Compass, these defendants all were given these numbers, and these were their sentences, and we can see that there's racial disproportionality, or there's gender disproportionality, or there's age, or whatever.
I'm not certain of the Compass instance itself. I believe actually that some of those arguments were raised in this very Compass case, the systemic bias arguments that I think you're alluding to. As you'll see in my slide on litigation, there are a number of challenges coming up to these kinds of assessments, including these questions of systemic bias. There's substantive and procedural due process challenges, and various others that I'll talk about. I don't know that the courts have really found a systematic way to grapple with them, and I'm
wondering if perhaps the defendants have, or whether professors or universities might want to, who are studying this issue and concerned about it.
Well, they absolutely are. And in fact, certainly the defense bar is jumping in with both feet. The last defense, the last Wachtell conference I went to on this subject was essentially, it was basically like defense attorneys attempting to become experts in the validity of these kinds of tools and trying to work with experts to get there. But of course, that is a very imperfect and challenging position for defense attorneys to be in, and it does raise the serious questions, I think, about procedural and substantive due process and how courts can ensure that in the context of tools that are very, very hard to understand, and in addition protected by these barriers to transparency.
Thank you. Our time is running short, so
Yes,
I want to let you get back to your prepared remarks.
I will continue to gallop along to make sure we have time for questions. This is really the full circle slide in this section, and it really, once again, asks this question about challenging the narrow framework of risk assessments. This is one of my favorite papers. I don't believe it was included in your packet simply because it reads a little technical, but it's called Interventions Over Predictions. And the thesis here is that these researchers effectively want us to recognize the difference between correlation and causation and go back to causation. And they assess current debates around these risk assessment tools in light of these tools effectively being new iterations of old statistical models that are used, in healthcare, housing, employment, et cetera. And their question that they would like to ask of machine learning tools is whether these machine learning tools can actually help diagnose and intervene rather than simply statically predict risk. They do that in one of my favorite exercises in this space, which is just to look at the history books. right? And they trace the way the criminal justice system has evolved through previous notions of statistical assessments in service of effective treatment, then tracing the static risk assessments that gained favor in the 70s and 80s that were, again, often based on criminal history, and to the post-90s sort of wave of risk needs and responsivity, and then tracing, I think, where machine learning has taken us, which is back to correlation and away from causation. And so, I think this is a worthwhile paper because it I think, really frames in sharp relief the ethical questions about relying on a tool that's effectively just about correlation, but I think in many of these cases, it does appear that it's assumed that causation is a part of the equation.
Would it be possible for us to have that made available?
Absolutely, yeah. Everything I reference, I will send if it's not already in the briefing book. Thank you. And then finally, I'm going to briefly touch on a taxonomy that I stole from Professor Moy, who will probably talk about it more, so I will not spend very much time on it. But I think it's a very useful taxonomy to think about how, beyond bias, how inequity seeps into some of these tools. And these are, I think, the issues at the heart of what the 2018 AI Now report on artificial intelligence calls the accountability gap. In other words, the ways in which inequity can seep into these tools. And Professor Moy talks about a multi-part, sort of bucket taxonomy of inequity. One of which, of course, is the garbage in, garbage out problem, right? That if your data is biased, it's hard to expect your algorithm not to be. The masking of inequity, right? So this idea that, well, this encompasses several things, one of which is the black box factor that we've discussed, the perception that the tool itself is neutral, the difficulty of actually unearthing the value choices within the tools, and then the legal frameworks, again, around trade secret that may not allow for adequate examination of that tool. The transfer of inequity is an interesting one because I think it posits that, for example, even if your agency wants to act in an unbiased way, if you import a tool that has biases embedded in it, you're effectively exporting external inequity into your existing systems. For example, if your face surveillance or facial recognition algorithms are biased, and you're using that tool, even as an unbiased agency, you will have biased results. Or risk assessments using the wrong data from a different jurisdiction where populations may be differently represented. The actual amplification of bias, I think, is something I started talking about several years ago, which when I first started saying this, I think there was largely skepticism, but I feel somewhat validated that there are now more and more studies that seem to show, for example, that if you use criminal history as a factor in predictive policing, you end up focusing on certain areas, leading to more entanglement in the criminal justice system, which of course is exactly a factor that the tool is looking for in deploying future policing resources. Right, so you end up with this cycle that amplifies that tilt in the data and singles out neighborhoods for attention and more attention. And then the oversight question as well, right? This question of these tools in the public sector often being deployed with no public elected decision maker ever having knowledge of the tool, no prior opportunity for the public to be able to examine it and its impacts on different communities. So as you'll see in our policy section, this is one where policymakers are starting to engage. So very briefly, On the legislative and regulatory side, I think you will see efforts to move the ball forward on AI. Out of these pieces, I'd like to highlight in particular in Washington State, we had the first of its kind legislation around transparency in artificial intelligence systems. We call them automated decision systems, or ADS, in public decision making. And the idea there would essentially be for a tool that either aids or entirely makes decisions on behalf of a public agency to undergo some level of public scrutiny and approval, in this case by the chief privacy officer of the state, before being adopted. The legislation also made clear that under the Washington law against discrimination, if a group was protected, you couldn't end run around that protection using an algorithm. A group was protected regardless of the algorithm's involvement. Other jurisdictions have looked at AI as well. New York City notably has a task force that Professor Barocas is on, and I'm sure we'll hear more about that later. But certainly it's a patchwork, and there's efforts, I think, to create both these kinds of procedural mechanisms for transparency and also substantive protections. The Washington law was both of those. And then, of course, the courts are seeing more and more of these cases. It's really a patchwork. As I mentioned before, there's substantive and procedural due process challenges, which I think are the most common. In trials, confrontation rights come into play. What do you do? How do you treat an instance where your accuser is essentially an algorithm? Right? It is a complicated and somewhat mind-boggling question. There's a whole area of litigation here around public records and accountability and transparency of these tools. In some of the criminal contexts, the First Amendment right of the public to observe trials, right, to maintain their faith in the justice system comes into play. Civil rights statutes, equal protection, consumer protection, many challenges to the technical validity of AI systems used in the criminal process, and of course trade secret. All of this stuff is in play, and there's no clear, and perhaps our learned professors will correct me, but I'm not seeing a clear trend in terms of how courts are grappling with these issues. So,
may I ask a question?
Yes, please.
You've focused here, rightly so, on the government use of these algorithms and the criminal justice system and social justice elements. I'm assuming this is pervasive, this form of AI is pervasive as well in the non-governmental, non-criminal sector. And I just wonder if you could touch on that very briefly, and maybe you're going to do that eventually anyway, but I'm curious about that.
No, I'm actually almost at the end, and you're absolutely right. I think because we have seen opportunity in existing statutes that allow us to get at algorithms used in public decision-making, that's where we focus. But you're absolutely right. Actuarial algorithms, for example, are a major part of healthcare decision-making. Right, and anything that involves risk, generally speaking, you are much more likely to find algorithmic engagement. And I talk to lawyers in this field all the time who I see as actually having been among the first to jump into algorithmic decision making because they simply see it as a way to slice and dice risk more efficiently than could be done by their individualized human assessments. Now, I think what that does is underscore the broader point that I think both RC and I are making, which is those entities are not necessarily looking at causation. They're not necessarily looking at the impacts of those decisions on populations. And it is, I think, frighteningly easy to end run around the brick and mortar protections, for example, in the healthcare system using data. Those challenges also, are out there. I've heard them batted around. I have not yet seen one succeed, but I think that wave is also coming, and it will be sooner rather than later. My guess is that you all will have to contend with that.
In relation to the government coming in with data privacy legislation and the trends, which I'm unaware of, maybe you are, but is there a concern that we're real sloppy on what data and information we're collecting and perhaps exporting and sharing? And I raise that because if you show up in response to a jury summons that you receive, you're asked to fill out a questionnaire, and those used to be just paper copies. Now they're done electronically that go somewhere. And some of the questions I've seen in cases we reviewed, it really touch upon privacy interests that maybe the person who's answering the questionnaire wouldn't want to be public.
Mm-hmm. Yes.
So do we see that being raised as more of a concern in the utilization or collection of data in the court system or other places outside of the medical records area? And how would the courts address that?
Yeah, I think that is an excellent and timely question, Justice Johnson. I think that what we have had in the data privacy space is sort of a chicken and egg problem, where folks have largely been willing to give up data because it is not transparent to them how that data impacts their lives, right? I may be all too happy, for example, to sign up for a smart meter in Seattle. Now we have protections in Seattle thanks to the ACLU, but a smart meter elsewhere that, for example, collects granular data about my energy usage at home. What could be wrong with that? As it turns out, analytics allow you to determine, for example, whether I cook all my meals in the microwave versus whether I use the stovetop. And guess what that may correlate with? That may correlate with my being a generally healthier person or a less healthy person. And if there are no protections on that data, wouldn't my HMO like to know? I think that's just, and of course that is one single data point among a universe of data points that may go into making decisions about how much I end up paying for healthcare. But I have no idea, and therefore I may be all too willing to say, sign me up, because of course I can also see my energy usage, which gives me the benefit of being able to reduce it. So those questions are being asked more and more. Right across the way, just this session, we had a major challenge around and a major dispute and debate around where that data protection privacy line should be drawn. We found ourselves on different sides than Microsoft, for example, as to where that line should be drawn. But I think the good news is people are taking it more seriously. There's also an effort to create a federal data privacy bill that's being advanced right now. Hearings, I think, are just happened, and it looks like that may end up being the case. In the longer version of this presentation at the very beginning, when I talk about data, protecting that and giving consumers agency around it, I think is the very sort of bedrock that will then allow us to have better control over AI systems more broadly and better transparency. And I know there are more questions. I will very quickly refer all of you to a list of questions I think can be helpful for any policymakers, whether you're legislators, regulatory, or the courts. The antiquated question to ask is, tech good or tech bad, which I used to get asked all the time. I'm thankful that I get asked that less now. But really a more sophisticated set of questions around why this technology, what values should govern its use, what's the evidence around the tool, and how can you verify those claims? Who wins and loses again, right? Who will be impacted depending on how you define fairness in the context of this tool? Who monitors that after the fact? Do you have a process by which those impacted by the tool can actually be at the table and importantly, is there any opportunity to say no? The correct answer may not always be yes.
There's another question. I know you're almost out of time, but the reason I think that we adopt some of these tools is because we recognize that humans are fallible, and this is a way to try to improve human decision-making. So if you're evaluating the bias in a tool, don't you have to also evaluate whether the human is also a biased tool and compare the bias before you decide to get rid of one over the other?
You absolutely do. Yeah, and I think, was what I had touched on earlier about, what direction does the bias go in? Are you replacing multi-directional bias with systemic bias across an entire system, right? And also the additionally complex question about how humans with political incentives and additional proclivities, again, all of which, there's more evidence around, interact with tools in certain ways, right? And one question, for judges is, are, for example, risk assessment tools a way for judges to abdicate responsibility around being the primary decision maker, exercising their discretion, all of the things that came up in the Compass case. So I think it's absolutely complex. It's not just one-sided, and there needs to be a careful consideration. What I will say is that there are so many studies in this area that have found bias that is systemic that gives me pause, right? Where a tool has not been evaluated in that way, we may not even know the kinds of biases it's bringing to the table before it's been adopted again by an entire court system. And so those prior questions, regardless of what the ultimate answer is, even if the answer is yes, should certainly be asked, and there should be a process by which the communities in particular that may be subject to disproportionate impacts can be a part of that discussion. And I think that one speaks for itself, and we've actually managed to make it to the end of the presentation. So RC and I are both open for your questions, Justices, for however much time we have.
Could I ask an elemental question? And it dovetails with the question Justice Gonzalez was just highlighting about the garbage in, garbage out. Or both of you referred to clean data. I really don't know what that means in this context.
I can take a start.
Why don't you come closer toward
Certainly.
We're
We're friends.
Or you can take turns one at a time. but-
We've learned a lot about each other working on this presentation together, particularly that neither of us has power over PowerPoint, which has a mind of its own. Sure. So a clean data set to me, is sort of an umbrella term referring to a wide variety of problems, right? That some of which have been touched on. Is, for example, the population that data comes from actually representative of the population that is going to be making decisions about, right? There's this question of sort of local, quote unquote, validation. You'll see the term validation thrown around a lot. It actually seems to mean a lot of different things to a lot of different people. And it's not necessarily a panacea, but one of the ideas behind it is this idea of localization. Another challenge around, clean data sets is this freedom from systemic bias by protected category, whether it's race, whether it's gender, which becomes very, very difficult and is not as simple as just yanking out categories that may be correlated, right? Because as it turns out, the tool continues to embody those biases, regardless of whether you're able to remove those.
So is it just an ideal?
Yes.
Okay, so because I haven't heard you identify a clean data set
Well,
yet.
I would say the ImageNet data is a very good example of what a clean data set could look like, but it's a relatively simplistic case, and you saw how much effort it took to assemble that, 256,000 workers it took to assemble that. So when you think about data is a competitive advantage for a lot of organizations. So you think of the larger companies, like I don't want to make... They derive their competitive advantage from the algorithms that consume the data. And so as long as there is value in the data, it's a matter of, I think, to what Shankar is saying, emphasize the outcomes you seek with the data and how the data plays into that role. So it's really purpose-built data for the use case and making sure, and I think transparency and scrutiny goes alongside with that, so I can vet the data. Sorry, talk too fast.
Yes, please, Justice Mattson.
So obviously, one of the takeaways, you haven't got to that slide, and maybe you don't, but is that we need to require more transparency so that we can then evaluate what the garbage, if it's garbage in or if it's actually value in and a value out. But My concern is that we haven't done a very good job of deciding that, even when we know, when our system is transparent, we know what went into it. And as you were talking, I was thinking about the Sentencing Reform Act, which my understanding was that was initially intended, at least in part, to correct for bias sentencing by judges. Now, in hindsight, we look and we say, oh my gosh, the result of that SRA, which is very transparent, we know what goes into it and we know the values, has resulted in over-incarceration of people of color. So I guess my question is, how are we going to do any better when it's even more difficult to see and have transparency into what goes in, when we can't even seem to do it very well? So is it always going to be a hindsight that we just have to, okay, well, we'll try this and then we'll measure it later? Because it does seem to me like there's a lot of human suffering that happens if that's your real tool, is to look backwards and say, oh, that's really not a good approach.
No, that is a great question, Justice. I think determinate sentencing is something I think about a lot, because I do think you're flagging something that had, good intentions behind it, and yet, resulted in a discretion maybe going places that was not anticipated. And I think here it is, for me, a question of changing our mindset around technology to being a more sophisticated one, where both policymakers and courts, I think, really are charged now to take the advice of technological experts to be able to examine tools. And it shouldn't be after the fact. I think that is the point of, for example, transparency mechanisms like the Seattle Surveillance Ordinance, which happens to be one of the strongest ones in the country, that is, even now examining retroactively 29 different technologies that the public really had very little or no information about even the existence of, let alone the functions of, until this point. But you flagged something that has been an insight for me as well, which is, at times in this space, transparency can be the enemy of accountability, right? If transparency is all you get, then you haven't gotten very far, because you don't necessarily have the opportunity to build on that and say no, or to say only under these circumstances. And so those procedural mechanisms have transparency for me as only the first step. I think it should be followed by a meaningful policy discussion in the case of legislatures, which I think my hope is Seattle can be a model for where lawmakers are becoming more sophisticated about the technologies. They're starting to ask more questions. Practice makes perfect as well, right? They're asking questions they didn't ask a few years ago. And coupled with this sort of additional skepticism and understanding that technology is the answer in some instances. It's not the answer in every instance. And getting that right takes before the fact process rather than just after the fact consideration by courts, which, as we heard at the very beginning, hasn't stopped a lot of harms of technology in the past.
If we're going to be adopting technology, and our concern, one of them is that there's bias in the technology, don't we have to know what our baseline bias in the system is that we're trying to beat first? Or are we trying to get to perfect, or are we trying to get to better than we're doing without the technology?
I will simply amplify. I think you're absolutely right, Joseph. I mean, we have broken brick and mortar systems that embody systemic inequity and bias in them. And I think those baselines, are documented. I think the shift in the conversation that's happened is the narrative used to be tech, this neutral thing, is going to come in and neutralize the biases that exist in our brick and mortar systems. I think the studies that I'm referencing, and I will send those to all the justices, and there are many more than I can send, do seem to support this idea that these technological layers on top of an inequitable system actually can amplify that bias. So it's not just maintaining the baseline, it's an actual amplification, which I think is an incredibly important point. And if you look at it that way, there can be a significant downside to adopting these technologies, We shouldn't go into that with our eyes closed. We should make sure we know what we're getting into. Then we can have a real conversation about whether existing inequity is improved upon by the tool. My personal ideal is that we actually build technologies that not only are neutral, but fight inequity in the system. And I think more technologists and policy advocates are trying to move us in that direction, but we're in a very incipient phase in that discussion.
I hate to cut off the questions and answers. Unfortunately, the justices asked some during the time, but I want to thank you both very much for excellent presentations that have set the base for continuing the conversation.
Thank you.
That's the most important thing.
Cool. Slides get up.
Let's see. Awesome. Good morning, and may it please the court. My name is Logan Kepke. I'm a senior policy analyst at Upturn, which is probably a nonprofit you've never heard of. We're a small nonprofit in Washington, D.C., and we focus on the promotion of equity and justice in the design, governance, and use of digital technology. And for the past 3 years, I've pretty much only been working on pretrial risk assessment research and advocacy, so I'm really excited to talk about it with you today. As part of that work, I helped co-direct the MacArthur Foundation's pretrial risk management project through their Safety and Justice Challenge, which some of you might be aware of. And I helped draft the shared statement of civil rights concern that more than 100 different civil rights groups signed on to that I believe was included as part of your materials.
I'm going to interrupt just so that the justices know your materials are behind tab 4.
Tab 4.
So if we want to make notes on your presentation, we can.
Thank you, I appreciate it. So a quick outline of what I'm going to talk to everyone about today. First, I want to provide a very basic introduction and sort of just a level setting for you, the audience, everyone who's watching, of what risk assessment is, how it works. Second, I want to critically examine the data upon which these tools are based. And some of this was just brought up by Shankar and RC. Next, I want to dissect what these tools actually predict. And finally, hopefully, we'll get to the real question, which is whether these tools actually promote bail reform goals, which to me are decarceration and the promotion of greater racial equity within the system. So how does pretrial risk assessment work? Risk assessment tools used today aren't really using the really advanced machine learning methods that were more described earlier. It's really basic statistics. It's really regression-based models. Frequently, what's new about it is the fact that it's being used, not the underlying methods. So how do they work? Basically, because they're regression models, the main goal here is to identify variables that are relatively predictive of certain outcomes. And in the pretrial context, generally we're looking at things like failure to appear, rearrest for a violent crime. And risk assessment tools use data about groups of people, typically about people who have been arrested, to assess the probability of that future behavior. So the creator of an actuarial tool might look at 50 different variables, much of which will be from criminal justice data, to figure out, of those 50 factors, what are most predictive of these certain outcomes.
You're talking about pretrial risk assessment tools in general, not necessarily anything in use currently in Washington?
Correct. I'm going to try and keep my discussion pretty high level to be applicable across the board, but I'm happy to take questions at the end to the extent I can answer them about Washington-specific things. So here's an example just to really situate you in how reliant these tools are on criminal justice data. So this is, they used to be called Arnold Foundation, now it's Arnold Ventures, and they have a very popular pretrial risk assessment tool called the Public Safety Assessment. And as you'll notice, it's just 9 factors. It's pretty easy to go through as a checklist. If you had all of the relevant information in front of you, you could actually score this yourself. It's pretty simple. Each factor is related to a score. You sum up the score, and then that score is attached to sort of a risk bucket. Oftentimes, that's a category of like 1 to 6, or for some tools, that's low, medium, and high. One thing I wanted to note about the public safety assessment that was sort of touched on earlier is it's built on 750,000 cases from a bunch of different jurisdictions across the United States in an effort to make it quote unquote nationally representative. One potential problem is that
Excuse me, somebody's phone is actually on speaker.
Oh, no
If you
worries.
could turn that off, we'd be able to hear the speaker. Thank you.
Thank you. One potential problem is, though we know it's based off potentially nationally representative data, we don't actually know what those cases look like, if the cases were later discharged, what the underlying charges were. We have no information as to basically the underlying data. We just know they came from a variety of different states, the federal system, things like that. So what are these tools built on? I want to highlight two sort of fundamental points about what the tools are built on. The first issue, in my opinion, and this is really coming from a civil rights perspective, pretrial risk assessment tools face in the civil rights community an inherent legitimacy problem. The very same racially inequitable criminal justice system that created mass incarceration also provides the data upon which pretrial risk assessment instruments are based. There's justifiably distrust that tools developed on data reflecting those biases will avoid perpetuating those patterns. So I want to dive into an example, and of course this is brought up before. This is the ProPublica example. So ProPublica examined Broward County, Florida's use of Compass. And the finding I think that was really unique that they contributed was the following. Among defendants who ultimately did not reoffend, black defendants were more than twice as likely as whites to be classified as medium and high risk. So it's 42% to 22%. So even though those defendants did not go on to commit a crime, they're nonetheless subject to harsh treatment and scrutiny by the courts given that risk score. Civil rights advocates argue that a fair algorithm cannot make those kinds of serious errors for one race group more than another. Now, the creators of Compass, they used to be called North Point, now they're called Equivant. They came back and said, hey, we are abiding by this traditional definition used in the statistical community, predictive parity, that was mentioned earlier. And that basically means scores will mean the same thing across race. So if you're given a score of 7 for both a black defendant and a white defendant, the underlying reoffense percentage will be the same. And that's a good thing. You do want scores to mean the same thing. But some research sort of eventually found that both ProPublica and North Point researchers were correct, and that this ProPublica finding is somewhat inevitable. And this, they say that this false positive imbalance, where defendants are assessed as high risk but did not go on to reoffend, will always hold if the underlying base rate of arrest diverges by race. In other words, arrest statistics mathematically assure that pretrial risk assessment instruments will overly classify some black defendants who would never be rearrested as high risk more often than white defendants. Some in the civil rights community will say, okay, given this problem, how do we proceed? One option is potentially to avoid predictive parity and to potentially optimize for equalizing false positive rates, so how wrong the tool is by race. I see two problems with that. Three. One, the research is pretty nascent here, so I'd be pretty careful to figure out where we're going. Second, the early research shows that you could actually make the burden of error greater for black defendants. So the proportion might shrink, but the overall total error might increase, which does not necessarily sound more just and more fair. And finally, it would likely necessitate different risk classification scales by race, which is likely constitutionally suspect. The second foundational issue I want to talk about with the underlying data to pretrial risk assessment tools is that today's predictions follow yesterday's patterns. That sounds like an obvious sort of statement, but for bail reform, it's a pretty important finding because it highlights a basic tension between statistical prediction on the one hand and bail reform on the other. And this is largely the subject of my recent law review article in the Washington Law Review, Danger Ahead Risk Assessment and the Future of Bail Reform. And the core finding is sort of this. On the one hand, to change a broken system, policymakers enact and implement policies that work to reduce the risk of rearrest and failure to appear and make the system more racially just. While on the other hand, policymakers ask statistical tools to forecast those same risks based on data from the very system under reform. That comes up. go. So I want to walk through, well, before I get to that example, actually, I'll give you two examples of policies where this sort of zombie predictions concept comes in. So two things are happening right now in bail reform. One policy is really seeking to reduce the incidence of failure to appear. So these policies are introducing text message reminders, redesigned court summonses that are more legible, understandable to lay people, phone call reminders, and some jurisdictions are even offering transportation help. And on rearrest, this sort of policy is a bit harder to follow, but decades of research show that time in jail worsens outcomes for defendants and can actually have a criminogenic effect itself. And that another line of research also shows that money bail is usually the but-for cause of most pretrial detention stays across the nation. So at the very moment across the nation that we're reforming money bail away or either circumscribing its use to limited circumstances, that sort of policy would likely have a couple effects. One, there would likely be fewer people detained pre-trial for a few days. Two, as a result, fewer people would likely be made risky because of avoiding that pretrial detention stay. And then overall, on the aggregate, you'd likely see an overall reduction in rearrest. And I want to walk through a quick example that highlights the two sort of foundational critiques that I've been laying out so far. New York City recently announced that they'd be redesigning their risk assessment tool based off a lot of data from 2009 to 2015. But the city's arresting practices during that period have been held unconstitutional and therefore are not and should not be a reliable guide, legally or statistically, to who will be arrested in the future. That's especially true for young men of color who are disproportionately stopped, questioned, and frisked during that time period. Second, the training data from 2009 to 2015 doesn't reflect a series of important policies that were just recently introduced in New York to help mitigate the risk of failure to appear and rearrest. So an example of some of those policies are a supervised release program that helps through more supervision defendants be released into the community safely, and it has had fairly remarkable success in New York. And just a few weeks ago, New York passed pretty landmark bail reform that almost entirely eliminated money bail for misdemeanor and nonviolent offenses. So here, a risk assessment tool built on data from 2009 to 2015 that predates reform would oddly compare post-reform defendants who have benefited from all these new policies to defendants who did not, who might have been detained for a few days simply because they could not afford a few $100s cash bail. As a result, as we detail in our paper, you could potentially overestimate risk through systematically. So what do these tools predict? I want to resituate ourselves in the legal context of the state. So Criminal Rule 3.2 really provides sort of the framework of there's presumption of release unless there's a likelihood of sort of three things, and I'm really oversimplifying here just to keep it easy. There's a presumption of a release unless there's a likelihood of non-appearance, a likely danger that the accused will commit a violent crime, or a likely danger that the accused will intimidate witnesses or interfere with the administration of justice. I want to walk through three sort of problems I see with pretrial risk assessment tools given that legal context. I'm going to put aside the likelihood of intimidation of witnesses and obstruction of justice. Risk assessment tools aren't really forecasting that. So the first is that most pretrial risk assessment tools that are used across the nation today produce composite scores of pretrial failure. That is the likelihood that the defendant will either fail to appear or be rearrested. But those two risks are really distinct and deserve different interventions from a policy perspective and a legal perspective. From a legal perspective, often across the nation, judges are asked to consider those risks separately. So a prediction that lumps the two together isn't necessarily truly helpful to judges. Second, from a broader civil rights perspective, pretrial risk assessment systems that present the composite risk of pretrial failure seem to be unnecessarily punitive. An example is that it might make someone needlessly appear medium risk because they merely need tailored reminders and potential supports to get to court. because they're labeled medium risk, someone could misinterpret that risk to make them a broader public safety threat. And given that many are rightfully worried about public safety threat pretrial more than necessarily failures to appear, predictions that lump these two outcomes together make pretrial defendants appear to be riskier than they really truly are. The second thing I want to walk through in terms of what these tools actually predict is that there's a significant gulf between the outcomes that pretrial risk assessment tools can measure and forecast and those that courts must assess. So on the one hand, that's usually they can measure and forecast rearrest and failure to appear, and usually courts must assess public safety risk, commission of violent crime, or flight risk. Here today, I'm going to focus on predicting rearrest, given that Criminal Rule 3.2 does focus on general non-appearance and doesn't specifically talk about flight, to my knowledge. Though the predicted outcome of rearrest is sometimes treated as a proxy for a person's public safety threat, in my opinion, that practice is imperfect at best and dangerous at worst. The majority of rearrests are not for serious offenses. And two, the use of arrest as a measure of criminality fundamentally assumes that people who do the same thing are arrested at the same rate. In other words, pretrial risk assessment tools ask us to assume that arrest is not a racially biased measure of criminality. Of course, that's an assumption that decades of lived experience and research teaches us to not be true, both as a statistical and civil rights matter. In fact, a long-standing body of research has established that arrest statistics document the behavior and decisions of police officers, prosecutors, and individuals who report crimes. The final thing I want to walk through in terms of considerations here is what these tools actually predict in terms of risk level. So labels like medium, high, and low, medium, and high risk insulate concepts of dangerousness from scrutiny. So here I wanted to walk through some percentages of popular tools. So the top is the pretrial risk assessment tool used in a federal system, then this public safety assessment, and then COMPASS. As you'll see, for the rearrest rate, for the highest risk of individuals, for the public safety assessment, it's about 26%. This is from a recent study in Kentucky. For medium and low risk defendants, it's about 13 and 5%. And I think that this really matters for a couple reasons. When people hear something like high risk, they are thinking about sort of perceptions of probability. So when we're thinking about, is it likely that this person will fail to appear? I don't have time to explain the full contours of this study, but it's essentially a study of 23 NATO officers trying to figure out how they perceive probabilities statements like this is most likely to occur or this is probable to occur. And things that are likely to occur are generally understood as amongst lay people having about a 60% chance. But of course, if we're predicting a likely non-appearance or a likely commission of violent crime, none of the available pretrial risk assessment tools get close to forecasting something 50% of the time. They're forecasting something much lower risk, perhaps 25%, 11%, or for the commission of violent crime, we're really looking at below 10%, so really, really rare. Finally, hopefully I can get to, does bail reform or do risk assessment tools actually advance bail reform goals? I want to walk through two examples, hopefully quickly. One is New Jersey and one is Kentucky, mostly because these states have completely overhauled their system to almost be entirely based on risk. In New Jersey, there was a constitutional amendment passed that took effect in January 2017. From 2015 to 2018, the pretrial jail population went from 9,000 to 5,000, which is a great reduction in jailing. And many have said this is directly attributable to the use of pretrial risk assessment. I'm not confident that's true, given that there are a range of bail reform measures that are introduced, including strong due process protections, 48-hour rules, a lot of other policies that are going to help release defendants. And there's another worrying trend that I think hasn't gotten enough attention with risk assessment. So the green line that you'll see is the expected rate of conditions given sort of the study of New Jersey and what you would likely see the conditions. So going from release on recognizance all the way up to preventive detention. And what you see is the plan was to have almost 50% of people released pretrial either on their own recognizance or on the least restrictive conditions of release. What you instead see is a huge shift to PML3, which is their most restrictive condition of release, not yet getting to electronic monitoring, an uptick in electronic monitoring such that it's actually almost bankrupting their reform efforts, and a huge uptick in detention, almost 20%. In Salerno, we're told that detention is supposed to be the carefully limited exception. To me, 20% of the time is still not close to the carefully limited exception. Finally, I want to walk through Kentucky. In Kentucky, Megan Stevenson did one of the best reports I've seen on the actual implementation effects of pretrial risk assessment. And she found that after Kentucky introduced the public safety assessment, it was true that for a time, non-financial pretrial release rates did go up for a bit, but these effects eroded over time, and eventually the impact on failure to appear and rearrest rates was negligible. Moreover, several years after implementation of the risk assessment tools, the rate of pretrial release was actually lower than it was before. And from a racial equity perspective, neither the bail reform law nor the PSA had any effect on racial disparities once regional differences were accounted for. So to close, I really like a quote from Sandra Mason's paper, Bias In, Bias Out, which I think is included in your materials as one of my favorite papers on the subject. She says that prediction overall is sort of putting a mirror up to our society. So what does pretrial risk assessment show what is it reflecting back? And here I wanted to quote in my parting moments from the shared statement of concern regarding risk assessment. Our system of justice is profoundly flawed. It's systematically biased against and disproportionately impacts communities of color. There can be no such thing as race-neutral prediction in a racially unequal world. Given that context, predictions based on such data, although they may seem objective or neutral, threaten to further intensify unwarranted discrepancies and disparities in the justice system, and to provide a misleading and undeserved imprimatur of impartiality for an institution that desperately needs fundamental change. Thanks, and I'm happy to take your questions.
We have about 5 minutes for questions. Are there any questions? Justice Mattson.
Oh, I was interested in the failure to appear component, and I know when I've sat in these decision positions, people emphasize how many times someone failed to appear. Is that though in comparison to how many times they did appear? So that's a question. It always seemed to me, well, you haven't told me how many times they appeared. You told me how many times they didn't.
It's a great question. Frequently, it's not the actual rate of non-appearance or appearance. And I think this also gets to a broader conceptual framing issue where typically these risk assessments provide, if they do provide the probabilities, it'll be sort of negatively framed. So a 20% likelihood that this person might commit a new crime. But in my understanding, the basic presumption of due process and of innocence should frame it the other way. It should be an 80% likelihood that they will not go on to commit a new crime, or an 80% of the time they will appear to court. So I don't think tools today are really getting to the rate at which failures to appear are not occurring. And hopefully designers of risk assessment tools might pursue that in the future.
Logan?
Might just say how many times did you appear as opposed to how many times you didn't.
Yeah, that'd be great.
Justice Yu.
Yeah, Logan, are there any tools, to your knowledge, that you have some confidence in that might be used now or being built? Are there any, especially in the area of pretrial risk assessment?
Confidence that would advance.
Right, and maybe even if it's combined with something else, but is there any tool that you would feel comfortable saying, well, you know, it might help a judge make a decision if you have this, this, and that?
In the abstract, probably not. The shared statement of concern regarding risk assessment does say that it's not sort of a per se objection to the use of risk assessment. If risk assessment tools are going to be used, really the only thing they can be used for is to quickly identify the large majority of people who can be released quickly. So to the extent that that is the policy framework, then I might readjust my answer. But I think the current policy frameworks that many tools are being entered into is not necessarily that framework.
Thank you very much.
Thank you.
Excellent presentation.
All right. Madam Chief Justice and the justices, at this time, before I ask leave of the court for a 15-minute break. I'm asking that the commission members who are present be allowed to stand and be acknowledged.
Please, thank you.
Commissioner
Will all the
Mueller?
Minority and Justice Commission members please stand?
Thank you. And Madam Justice, I'll ask for leave at this time for a
Yes.
15-minute break.
Before I grant that, which I will do for everyone's convenience, we're going to move the break up 15 minutes because we didn't want to go quite so long without having a break. So we will take a 15-minute break now, which means we will reconvene at 10:45 with our next presentation. I do want to thank the Minority and Justice Commission members who were able to be present today, for being present, but also for all your hard work and efforts on all of our behalves, and for what is so far and will be, I'm sure, most excellent symposium this morning. So at 10:45, please be in your seats. I'd also like to ask when you come in that you sit as closely together toward the center. One, it'll help you see the screen, but we have people that are standing who might want to sit and not really can't really figure out where the spaces are. So with that indulgence, then once everyone's seated, you can kind of spread out again if you wish. Thank you. To see you at 10:45. Oh, one more thing. The bathrooms are right outside here, only single stall. So if you need to go more quickly, there is downstairs many more stalls down the stairs heading toward this side. Thank you. Unexpectedly for a short period, and she will rejoin us as soon as possible. Please begin.
All right. Good morning, and may it please the court. My name is Laura Moy. I'm the executive director of the Center on Privacy and Technology at Georgetown Law School. We are a small think tank. We do research and advocacy around a range of privacy and surveillance issues. We focus on issues where there's something to say about disproportionate impact on historically disadvantaged communities. As an individual, I came to this field of work having worked before law school as a cell site location analyst at the Manhattan DA's office. So I had worked at the Manhattan DA's office on that side, applying technology in cases and prosecutions, and as a result became interested in how layering of some of the new technologies that we see entering the criminal legal system on top of an existing context where there are a lot of problems, including existing inequities, how that can affect outcomes or exacerbate outcomes. And so I'm going to, I think, and actually I should start, I meant to start this way. I wanted to start by thanking all of you for having this symposium. This is a fantastic event. It's truly an honor to be here, and thank you to the Minority and Justice Commission also for putting this on. It's also such an honor to be speaking at this event with so many people whose work I really admire. I'm really looking forward to seeing some of the future speakers, and have very much enjoyed presentations by some of the others. So there is a growing recognition, there's a growing recognition, I think, that when you take new technologies and layer them on top of an existing context of inequity, then the outcome is not neutral, right? That the outcome can exacerbate the underlying context in which you have layered the new technology on top. And this realization is coming and being spoken about more in no small part due to the work of others who are here today, and due to the advocacy of organizations like Shankar's organization that are doing advocacy around these issues. But often I find that in advocacy, including in my own advocacy on some of these issues, we sometimes see the characterization of how police technology, I'm going to focus on police technology here, but a lot of what I will say is more broadly applicable to the layering of technological tools onto government decision making. A lot of those conversations, including in my own advocacy, tends to sort of overgeneralize the problem here, or to overspecify it in ways that make it a little bit difficult to figure out how to approach these problems from sort of a 10,000-foot view and figure out what to do about them. So Shankar previewed a little bit what I'm going to talk about. But let me lay the groundwork a little bit more. So an overgeneralization of that looks like this, right? It just says police technology aggravates racial inequity without really delivering the nuance of how that takes place. And you're getting a lot of nuance today, actually. So here's an example of that. This is from a letter from 45 organizations in 2016 to the Chief Privacy and Civil Liberties Officer of the Department of Justice and the Chairman of the FCC. New technological tools that amplify police power can amplify existing biases in policing. And I helped write this letter. So as I say, I have been responsible for some of this overgeneralization in my own work. And when we see overspecification of the problem, the problem is sort of characterized as this particular type of police technology aggravates racial inequities, right? So an example of this, here's an example from face recognition. And this, by the way, is all very useful detail. It just, again, I think that sometimes it makes it a little bit difficult to kind of zoom out and figure out what to do about the problem as a whole. So here's an example from face recognition. This is a paper written by some engineers in 2012. When examining the race and ethnicity cohort, all 3 commercial face recognition algorithms achieved the lowest matching accuracy on the black cohort. And I'll talk a little bit more about this paper later on in the presentation. Here's an example from the predictive policing context. Allowing a predictive policing algorithm to allocate police resources would result in the disproportionate policing of low-income communities and communities of color. This is from a paper put together by some statisticians examining predictive policing back in 2016, which I will also talk about in just a bit. And to provide a third example, looking at cell site simulators, these are fake cell phone towers, right, that police agencies sometimes use to try to locate an individual if they know the phone number of the person that they're looking for. The problem of racialized surveillance is particularly pronounced in Baltimore, clearly reflected in its racially biased deployment of cell site simulators. And this is from a complaint that actually I filed on behalf of these organizations, Center for Media Justice, Color of Change, and New America's Open Technology Institute in 2016. We filed this complaint with the FCC arguing that use of cell site simulators in Baltimore by local police there was in violation of the Communications Act. So again, here's another example of something that I have been responsible for in my own advocacy, but I think that this, and while useful in this particular context where we were making this argument, I do think that characterizing the argument with such a level of specificity can sometimes make it difficult to know what to do about it. So what I suggest, and what Shankar previewed for you a little bit, is to parse the problem and explain how the layering of police technology onto an existing context, in many cases an existing context of racial inequity, is not just one problem, but 5 problems, right? So it can, a new technological tool can replicate inequity. As Shankar said, this is when you build the inequity into the tool, oftentimes using data that comes from the underlying inequitable system. And as a result, once you start implementing the tool, it can replicate the underlying inequity. A new tool can mask inequity. As Shankar says, this is when a new tool may make the underlying inequity more difficult to detect, essentially hiding it. A new tool may transfer inequity, and so this is when essentially a new tool acts as a virus importing an inequity that exists outside of the system into which it is brought into that system. A new tool may exacerbate inequitable harms by augmenting the ability of the system that uses that tool to do harm where the system that uses that tool is already acting in a way that is inequitable, thereby exacerbating the inequitable harms. And the last is that these new tools can compromise inequity oversight. And so that's when the adoption of new tools may frustrate the ability of policymakers, courts, and the public to rein in what could be inequitable practices in an underlying system. And I just want to make clear that these are not mutually exclusive problems, right? These often are overlapping and coinciding in adoption of one tool. But I think that looking at it through this lens of having 5 different problems can help us to see, can sometimes help us see more clearly, what the problems might be as we adopt some of the new tools that are proposed. So I'm going to go through them one by one and provide an example to illustrate most of them. So in replicating inequity, and I think we also just had a great example of this. Logan's presentation gave us a great deep dive into how pretrial risk assessment tools can replicate inequity, and sometimes can keep inequity alive that are programmed into the system, even after reforms have been adopted into the pretrial release approach. And we will also hear in a little bit from Solon Barocas, who has done a lot of research and writing about how bias can enter into an algorithm. So I'm going to provide you with an example here. So here on the left is a map of drug arrests in Oakland in the year 2010. And this example that I'm going to provide now comes from a paper put together by 2 statisticians, Christian Lum and William Isaac, in 2016 called To Predict and Serve, in which they ran an experiment using a popular predictive policing system. So much of what I'll show you is from an experiment, and I'll try to be clear about what's real versus what comes from the experiment here. But on the left is a map of actual Oakland drug arrests in the year 2010. And on the right is a map of the estimated drug users in 2011 in the Oakland area. So you can see that there's a concentration of enforcement in a particular area. And so the statisticians who were studying this and running this experiment, they hypothesized that, of course, if you take one of these things to train a system that then will make predictions about drug use in the area, then you're going to end up with an inequitable outcome, because you're layering it on top of and building into it existing inequity. So that's what they did. So they took a popular predictive policing system. This is not real. This was not done in partnership with the vendors of this tool. This was done by statisticians using this off-the-shelf tool, and they programmed in the information, data about drug arrests in that area. This is also, predictive policing often is not used to predict drug crimes. So like a lot of things here are particular to this experiment that really was just an experiment to illustrate to the greatest extent possible how inequity can be replicated by a system. So they programmed the system, they trained the system using data reflecting Oakland drug arrests in 2010. And of course, the system came back and predicted drug crimes in similar areas, a similar concentration of areas as what you saw in the first image from the prior slide. So then what these statisticians did is they did a comparative analysis of the racial breakdown of people in the areas in which the predictive policing system trained on the bias data would predict drug crimes to occur. And they compared that against the racial breakdown of drug users in Oakland at the time. And as you can see, as you might expect, there was a dramatic overrepresentation of black people in the predictions made by the system, because the system had been trained using this underlying bias data. So if you were to take a system like this, again, this is just an experiment, but if you were to take this and adopt it, then you can see how this type of example illustrates how the tool can replicate the underlying inequity. So with masking inequity, we see that adoption of some of these tools can make it more difficult to see the underlying inequity. And to help you understand that, here's a quote from one of the architects of the Los Angeles Police Department's predictive policing system. So one of the architects of this system told the New York Times in 2012, this quote, "The computer eliminates the bias that people have." Obviously, and I think that this whole day is largely about the fact that that is not the case. Nevertheless, this myth perpetuates, and it sometimes is intentionally perpetuated by the very vendors that are offering some of these tools. A problem that I think you may hear a little bit more about from Elizabeth Joe when she speaks about, is she has done a lot of work looking at the influence of vendors of these police technologies on the regulatory environment in which they're introduced. So the third category of ways in which these new technologies can aggravate underlying inequity, transferring inequity, is when you take an inequity that exists outside of the system in which the tool is going to be adopted, build that into the tool, and then adopt the tool, thereby importing the inequity into the system. So this slide shows an image from a paper that was released last year by two computer scientists who looked at, not at face, and let me back out here for a minute and say, face recognition can do a lot of different things. One possibility is face identification. You hear a lot about face identification. This is when police agencies use a computer to try to tell them who the person is in a photograph that they're looking at. This study looked at gender classification algorithms, which is something entirely different, but developed using a lot of the same techniques and sometimes by the same teams of engineers. But these two computer scientists, they took some commercial off-the-shelf gender classification algorithms, so software that is designed to try to predict the gender of a person whose photograph you introduce to the system. You give it a photograph and you say, is this a man or a woman? And it tries to guess. So they did a test of these three commercial off-the-shelf products using photographs that they sourced from all over the world that included not just light-skinned people but also dark-skinned people across an entire spectrum, and looked in particular at intersectional groups. So looked at the performance of these algorithms, not just at how they, not just on women versus men, not just on dark-skinned individuals versus light-skinned individuals, but looked at what the performance of the algorithm would be if you considered darker men, darker women, lighter men, and lighter women, and found that the algorithms that they tested in some cases performed barely better than a coin toss at guessing the gender, in particular of dark-skinned women. So again, this is gender classification, not face identification, but it shows a sort of extreme bias that is built into this tool. And again, some of the other speakers can speak more about how that gets in there. But one of the hypotheses about how this happens is that, well, let me name two actually. Two hypotheses about how this happens, among others, are one, that the underlying training data is itself inequitable, that the underlying training data used to train the, perhaps in this case, gender classification algorithms might include a disproportionate representation of light-skinned men, or disproportionately poor representation of dark-skinned women at a minimum. And so that inequity in the training data sets then makes its way into the tool, and if a tool like this is adopted for some decision-making purpose or to assist in some decision-making purpose, then that inequity can be sort of grafted onto the system that adopts it. The second, a second sort of related hypothesis about how this occurs, and this is very much at a macro level. There are obviously much more nuanced discussions of how such bias can enter into algorithms. But another hypothesis just has to do with teams of engineers. And if you look at and companies are doing, I should say also, companies are doing a lot of work to try to improve on these things. But if you look at the teams of engineers who are developing these tools, if you have a disproportionate representation of white men on the engineering teams, then sometimes you might end up with problems like this getting overlooked by your teams of engineers.
So could I interrupt and ask you,
Absolutely.
This is probably such a basic question, but I actually don't know. You mentioned the training set. So are facial recognition software algorithms built on something like ImageNet where they're just trained and they see what they see? Or are they built to kind of replicate the way humans poorly, as it's been shown, identify people through kind of a triage, you know, like I think a lot of the studies since the 70s show the first thing people see is race, and then maybe they see gender. So which, or is it a combination of both? I don't really
That's
know
a good question. And the answer is actually it depends, right? You know, and this is kind of a this is kind of a problem that I might get to a little bit toward the end of the presentation with some of these tools in general, which is to say that face recognition algorithms, you know, although we may lump them together, or in this case, gender classification algorithms, aren't just one thing, right? It's sort of a category of lots of different tools that all do slightly different things. And some may be trained just using a machine learning approach where they are trained on a data set and then attempt to do the best that they can at identifying faces. But others might be more intentionally programmed to do something like what you just described, to sort first into categories and then to identify, or even to, or might be programmed specifically to find particular focal points in the face first, like pupils and shadows that indicate the end of the nose and the width of the mouth, and to make measurements regarding those things, and then those measurements might be compared to look against you know, templates of faces that are already known to the system, to look for similarities in the measurements. And so there's lots of different ways that they are developed, and unfortunately it's just a complicated answer. All right, so here is another, just to provide another example. Here's a slide that represents data from a study by engineers that were looking at face identification algorithms. So the prior one was about gender classification algorithms. This is just showing you that in one study from 2012 looking at face identification algorithms, the COTS-A, COTS-B, and C there, those are names for commercial off-the-shelf face recognition products. But these engineers found a significantly lower identification success rate at looking at the faces of black versus white subjects. Not as pronounced as in the gender classification study that we saw, but still clearly there.
What is a Hispanic face?
It's a good question. It's a good question. Yeah, and unfortunately I can't provide an answer to your question right off the bat without going back and looking at the paper, but it's a good question. All right, so and I just want to point out that sometimes this as I had mentioned before, these categories of ways in which tools might aggravate existing inequities are not mutually exclusive. This is an example of how a problem where you have transference of inequity from one context into another might also sort of feed into the masking problem by making it difficult for the entity that adopts the tool even to recognize that the inequity exists in the tool that it has adopted, and therefore sort of enrolling the agency or whatever adopting entity you have as a complicit entity that can perpetuate the masking effect. So this actually comes from records that we obtained in production of one of our reports on face recognition software from the Seattle Police Department. So this is a frequently asked questions document from the Seattle Police Department, where there is this question on there: is the booking photo comparison system biased against minorities? And at least at that time, in 2016, or maybe 2015 when we obtained this record, the answer in that questionnaire, in that frequently asked questions document, was no, because machine vision only looks for a similar constellation, a mathematical algorithm. It does not see race, sex, orientation, or age. The software is matching distance and patterns only, not skin color, age, or sex of an individual. Which might be sort of true, right? But it clearly misses the point of the question, which is whether or not there is bias built into the system. I'm going to speed along because I know I'm running low on time. So I'm going to talk about another concrete example in exacerbating inequitable harms. So this is largely about that complaint that I mentioned before and filed with the Federal Communications Commission back in 2016. So in 2016, the Department of Justice found that the Baltimore Police Department exhibited racially disparate impact in its practices at every stage of the enforcement actions, from the initial decision to stop individuals on Baltimore streets to searches, arrests, and uses of force. So if you take that and you layer on top of that use of a powerful technological tool by the agency, then you may find that, of course, that the tool will be used in a way that also exhibits disparate impact. And so that's what you see. So on the left here, you see a map of black residents in the city of Baltimore in 2010 from the census. And on the right, a map of cell site simulator uses in the city of Baltimore as uncovered by an investigative reporter, Brad Heath, in response to a Freedom of Information request. And when you layer the two, one on top of the other, you can see clearly that there's clearly a concentration of uses of these devices in neighborhoods that are heavily populated by black residents. And that's for a number of reasons. And you can say that is where the crime is, that's where the police are going. This may be true, but part of what we're talking about here is about potentially inequitable harms in neighborhoods. And one of the things that happens with this tool is that, so again, these are cell site simulators, they're fake cell phone towers. They essentially trick people's cell phones into sending information to them by acting like a real cell phone tower. And this enables police agencies to use them very effectively to locate phones that they're looking for. But these devices can disrupt the cell phone network in their vicinity, and as a result, they do harm not just to an individual that they're searching for, but can do harm to within a 2-block radius of where they are used by making it difficult for people to make and receive phone calls. I am out of time. And so I think I'm just going to show one more slide, I think, or I'm going to say 2 more things.
Ms. Moy, I want to say,
yes.
Your time is up because they were allowing 5 minutes for Q&A, but we've had a couple of questions, and so just knowing that's your trade-off. So
got it.
Choose what you'd like.
Thank you. I appreciate it.
At 11:15, you will be done.
Appreciate it very much. All right. So just 2 more things on the compromising inequitable oversight. So one thing is to say, so on the obfuscation side, we have had a really difficult time. The introduction of these tools can make it really difficult for advocates and for policymakers to understand what is happening. We've had a really difficult time recovering some of the records that our research has been based on. We've been in litigation with NYPD for over 2 years trying to recover documents from that agency about its use of face recognition technology. And as you might hear from some of the other speakers, oftentimes vendors and agencies that are using these tools rely not just on freedom of information exemptions, but also on trade secrets and non-disclosure agreements to try to obfuscate how the tools are being used and how they function from the public. And on the technical complexity side, the technical complexity of these tools, once you introduce them into a system that traditionally has been overseen essentially by generalists, then it makes it really difficult to exercise a very effective oversight. And it's very difficult for legislators, but it can be very difficult for courts as well, and for advocates who operate before those courts to understand the nuances of the things that they are attempting to discuss or to combat. And so when you layer a technically complex tool like those that we've been discussing on top of a system where you have, for example, defense attorneys who are already struggling under burdensome caseloads, then it may make it extremely difficult for them to advocate effectively on behalf of their clients and truly bring before the court some of the arguments that we believe might be there, but that it might take an unusually high number of hours to uncover and to sufficiently explain. I'll stop there. Thank you.
Are there any questions from Ms. Moy, Justice Mattson, and then Justice Gordon-McLeod?
Is there a good place to look to understand what some of these technologies are being used for? You didn't have time to get into it. I would be interested to know what is being being done with these.
Certainly, yes. So, and on police use of face recognition in particular, my center released a big report in 2016 that synthesized the results of Freedom of Information requests sent to over 100 law enforcement agencies across the country. That report is still we've learned some more since then, but it is still highly relevant, and it is at perpetuallineup.org. We will have 2 additional papers coming out next week, and I'd be happy to send them to you, also about how agencies are using face recognition technology. And I think, so you should have a copy of the paper there, which does cite, for example, the cell site simulator complaints. It cites well, Logan Kepke's work on risk assessment, and you can gather more information from some of those. Does that answer your question? Okay,
Could you repeat the website?
Perpetuallineup.org.
Justice Gordon McLeod, and you have about 2 minutes, so you can time your answer.
All right.
I wonder about whether any of the things that you're saying about technology as a tool is true of all other tools, or whether it's exclusive to technology, because I think of the change in the 80s to determinate sentencing and mandatory minimums, federal side and most state sides, and you could make exactly the same criticism of the generalizations on which those schemes were based, criminal history being a predictor, for example.
Yes, I do. I actually do. I do think that this framework for understanding how new tools may aggravate underlying inequities can be applied to adoption of new practices in general. It's really a tool for a taxonomy for attempting to identify how a change in practices or adoption of a new tool may aggravate underlying inequities. And so an example that someone else raised in another presentation that I gave on the same paper was that of the use of drug sniffing dogs, right? Couldn't you consider drug sniffing dogs to to create problems in some of these categories? And I think you absolutely could, yes.
But then to go back to Justice Gonzalez's point earlier, don't you need to know what the starting point was, because determinate sentencing was brought in, at least in part, to eliminate disparities in sentencing that resulted from subjective determinations by judges.
Mm-hmm, yes, and I think I'm really glad that you asked that question, because I think that one of the takeaways that I would hope you would get from the presentations today is that it's really important for us not just to look at at what a tool does vis-a-vis the status quo, how it improves upon the status quo, but to ensure that once we adopt a new practice or a new tool, that we have systems in place to continue to scrutinize them and to force further improvements upon the operation of it. So even if you end up with a tool that sort of replicates inequity but does so at a lesser level than the prior existing system might be, is there a way that we can ensure that we are continuing to require the developers of that product to continuously improve it, such that the improvement is a trend and not just a one-time advancement?
Thank you, Ms. Moy. Perfectly timed.
Thank
to
you.
11:15.
Thanks very much.
Now have our panel discussion.
Good morning.
Morning.
I'm Judge Teresa Doyle, and we're fortunate enough to have yet 3 more experts to engage in our panel discussion. And we'll start over here with Mr. Heiner.
Good morning, Justices. My name is David Heiner. I am a strategic policy advisor with Microsoft. Thank you for the invitation to appear here today, and thank you to the Minority and Justice Commission as well. We've been hearing about concerns with AI all morning. I wanted to take a few minutes to address how Microsoft and really the broader global community of AI developers and policymakers is seeking to address these concerns. We focused this morning on fairness. There's actually additional concerns. We could have additional symposia about them, and I'll address this at a very high level. We think it's really, really important to address these concerns in a very deep way because the potential for AI to improve our lives is so great. And so we think we need to take a principled approach as we develop this software to enable it to be seen as trustworthy and, as Shankar was saying at the beginning, to conform to societal values. Boy, it's a little laggy. Okay, so to begin with, and I think this is somewhat implicit in the discussions this morning, the technology is very powerful. You know, we do have these sort of hype cycles in the tech industry where something's like hyped up is really big and then it kind of falls flat. It doesn't feel like this AI sort of revolution, if you will, is hype. You know, the market capitalization of Microsoft, which is very high, and Apple and Amazon, Google and Facebook, it's largely based around artificial intelligence. What we are talking about here is a form of intelligence. So right off the bat, that seems like something that would be pretty important. We are teaching computers to do things that once only people could do. Things like see, we've been talking about the images, but also hear just the sounds a voice makes and turn that into words, and then a much more challenging thing, understand what those words really mean. And so this revolution that we're living through in AI, and we're in the early days, it could be as fundamental as other technological changes like the printing press in the 1300s, or electricity, or the internet. Inevitably, it raises new societal issues, and we'll need to work through those over time. It's really important that we get this right because there's the possibility of AI improving our lives in so many areas, which we haven't really touched on this morning. We're focusing on criminal justice, but there's the healthcare area, there's transportation, there's education. For many years, I was the chief lawyer at Microsoft responsible for accessibility compliance, and so I had the occasion to learn something about how AI can help in the area of accessibility. And I brought with me a short video, it's 2 or 3 minutes, that will show one application of AI relating to accessibility. Do you want to manually play it?
I'm Saqib Sheikh. I lost my sight when I was 7, and shortly after that I went to a school for the blind, and that's where I was introduced to talking computers, and that really opened up a whole new world of opportunities. I joined Microsoft 10 years ago as a software engineer. I love making things which improve people's lives. And one of the things I've always dreamt of since I was at university was this idea of something that could tell you at any moment what's going on around you.
I think it's a man jumping in the air doing a trick on a skateboard.
I teamed up with like-minded engineers to make an app which lets you know who and what is around you. It's based on top of the Microsoft Intelligence APIs, which makes it so much easier to make this kind of thing. The app runs on smartphones, but also on the Pivot Head smart glasses. When you're talking to a bigger group, sometimes you can talk and there's no response, and you think, is everyone listening really well, or are they half asleep? And you never know.
I see 2 faces, 40-year-old man with a beard looking surprised, 20-year-old woman looking happy.
The app can describe the general age and gender of the people around me and what their emotions are, which is incredible. One of the things that's most useful about the app is the ability to read out text.
Hello, good afternoon. Here's your menu.
Great, thank you. I can use the app on my phone to take a picture of the menu, and it's going to guide me on how to take that correct photo.
Move camera to the bottom right and away from the document.
And then it'll recognize the text. Read me the headings.
I see appetizers, salads, paninis, pizzas, pastas.
Hi. Years ago, this was science fiction. I never thought it would be something that you could actually do, but artificial intelligence is improving at an ever faster rate, and I'm really excited to see where we can take this. As engineers, we're always standing on the shoulders of giants, building on top of what went before. And in this case, we've taken years of research from Microsoft Research to pull this off.
I think it's a young girl throwing an orange frisbee in the park.
For me, it's about taking that far-off dream and building it one step at a time. I think this is just the beginning.
So that was the beginning. That video was made when the product was under development. It's available now as an application for the iPhone. So if you have an iPhone, you can go to the App Store. It's called Seeing AI, and you can test it out yourself. We can see the benefits of AI, but we need to get after the various issues that it's raising. And fortunately, there is a global dialogue going on this subject, which Microsoft is participating in. So for instance, the Organization of Economic Cooperation and Development, based in Paris, has recently, well, they're about to, this month, release a set of principles, high-level principles to guide the development of AI. Groups like the Partnership on AI, which is companies developing AI systems, and civil society groups are working on principles. Academic-focused groups like Data and Society, AI Now, and even religious groups. There's a group in Seattle called AI and Faith that aims to bring a faith perspective to the development of principles governing AI. Our sense is that the core principle we need to work toward is trust. We need to build trust in AI systems because people won't use the systems otherwise. These systems, to the extent that they relate to AI about people, they depend upon data about people, and so people won't share that data unless they trust the systems. This doesn't seem like a profound point, right? Every company needs to build products that are trustworthy, but in the context of AI, it seems particularly important because the technology is so powerful and because it does depend upon data. And so we've been thinking about how do we build trust in these systems, and it really goes back to the point that Shankar opened with, which is we have to think about what are our values. And for a global multinational like Microsoft and many of the other companies that are building these technologies, that's actually a kind of tricky question because values obviously differ around the world. But we do have a starting point. We just celebrated in December the 70th declaration of the UN Declaration on Human Rights, the 70th anniversary. Can you make it go back one? And there the world came together after World War II to develop a set of common norms. And I've listed on the slide, I won't go through them, some of the, I think there's like 25 of these principles, some of them that appear to be particularly relevant to the development of AI. So we can at least begin to look at them as a guidepost for how to build trustworthy systems. Our approach at Microsoft really boils down to three basic steps. The first is, and it really goes, Justice Gonzalez, I think, to the import of a number of your questions. We want to build AI systems to augment human capabilities. Think of, for instance, move from the judicial context to a medical context. Think of a doctor who's in a part of America where she may not see every disease, but the AI system is trained on every disease. And so it can help that doctor to recognize perhaps what is a rare disease. Or a radiologist looking at those charts, looking for a cancer tumor. Studies have shown now that if you combine the expertise of the doctor with the expertise of the AI system, it's better than either of them acting alone. And part of the reason for this is that humans have some capabilities, AI systems have others, and we can marry both. So AI systems are based on probabilistic reasoning. I mean, everything we've talked about this morning, it's all numbers and correlations. Those systems are really good at that. People are not so good, actually, at probabilistic reasoning. Computers never forget. Of course, we're forgetful. Computers inherently don't have human biases. Laura had that one quote about a police officer was making the point, well, the system has no bias. There's a germ of truth to that, in that the system is just zeros and ones. It's just math. So there's at least some potential with an AI system to eliminate human biases. Of course, the challenge is that the system is trained on the world in which we live, which reflects biases, and that's what we've been discussing this morning. The second aspect of this is we aim to make AI available to everyone. So, at Microsoft, we're a platform company. That means we're making tools for end users. We're also developing tools at a platform level, which means other developers can come and build on top of them. The third point is really the core here, I think, which is we aim to take a principled approach to the development of AI. And so about a year ago, we articulated 6 principles. We believe AI systems should treat everyone fairly. We've spent the morning on that. We believe the systems should be reliable and safe. We touched on reliability a little bit in connection with the gender classifier for facial software. They should be private and secure. They should be inclusive. This is making AI available to everyone, including, for instance, helping people with accessibility challenges. They should be transparent. We've touched on this a little bit this morning. Obviously critically important in the context of criminal justice, but also important in the context of any AI application that will have significant impacts on people, whether it's healthcare or who's going to get a job or credit or anything else. And then finally, accountability. So the people who design these systems and the people who use the systems need to be accountable. An example of accountability is facial recognition technology, where Microsoft believes that the vendors of these technologies need to be accountable to the law. We're in the early days, and so there really is not much regulation at all of how facial recognition technology works. There are some important societal trade-offs that need to be made between things like privacy and security and law enforcement, and we believe that we need to do that. We contributed to a bill that ultimately didn't pass across the street that would have taken a first step towards regulation of facial recognition software. We believe that firms that are developing this technology need to be transparent about how it works and need to engage with policymakers, engage with regulators to explain how it works, to explain the limitations of the systems. Because as powerful as they are, there are also real limitations. And that's why we have called for legislation in this area. The final point is simply that we've written a short book on the topic. We didn't want to include a whole book in your reading materials, but we've tried to address these 6 principles more fully. And if you're interested, it's a free download from Microsoft.com, or if you like the Kindle version, it's available for a nominal price from Amazon. Thank you.
Good morning. I want to thank the Minority and Justice Commission for inviting me here today, and I'm also so honored to be talking with the justices this morning. My name is Elizabeth Joe. I'm a law professor at the University of California at Davis. I have written about policing technology, and I was asked here to sort of summarize, what needs to be emphasized from the previous presentations, and I wanted to focus on something that's been brought up a couple of times in this morning's excellent presentations, and that is the private influence on AI. And I want to speak specifically about policing, but I think it has applications to a lot of areas that have been brought up today. And the fact is that when it comes to policing technology and the police use of AI technology,
it's mostly the use of products that are privately developed and sold by private companies. But you might ask yourself, well, what's the big deal? I mean, don't police departments do that all the time? Don't they contract with vendors all the time? Of course they do. But the problem here, and maybe this is a framing way of talking about it, framing it this particular way. The private influence on AI in policing introduces a kind of double opacity or secrecy. So we've already talked at first about one layer of secrecy or opacity today, and that is, well, it's often hard to figure out why an AI system came to the decision that it did. We may not be able to explain that, and you've heard a little bit about that this morning. We may not know exactly what were the things, the data set that the AI algorithm was trained upon. That's a kind of opacity too. But the second layer of opacity here that I want to talk about is that private companies are profit-making companies, and they also have an interest in protecting their own products. And they don't want people stealing their ideas, of course. So normally the doctrines of intellectual property protect their interests. But what happens when these are products that are used by public agencies like law enforcement agencies? So that's that double layer that I'm talking about. One is the difficulty of understanding AI decision-making itself, and the current state that we live in, which is this double layer of IP protection written broadly or understood broadly, that is now a problem, I think, for courts and legislatures. And this is where I think that courts can play a crucial role in these early questions about how to understand or to resolve this clash between what were two very different formally areas of law, right? Typically, DAs and defense attorneys don't know anything about IP. And IP lawyers know nothing about the criminal justice system. But now we're seeing that these two areas of law are definitely coming together. So I want to sort of give you an example here, right? Some of this comes from some of the earlier presentations. Let's say a defendant wishes to know why he or she was stopped by a police officer. Maybe the government says, well, facial recognition technology, said that you were a match, or there was a suspicion algorithm suggesting that your habits and patterns were the reasons why you had to be stopped. And this person wants to challenge the basis of that stop. Well, what if the government's position is, well, we can't tell you?
Objection, hearsay.
Right. We can't tell you because maybe we've signed a non-disclosure agreement with the company when the police department bought the program in the first place because they said it was a trade secret. Or maybe the contract signed with the police department and the private company signed over all of the ownership of not only the analysis, but also all of the data. We don't own it. And so we can't give it to you. Or because the police department no longer has a license. This is an old case, let's imagine. We no longer have a license with that company. We switched vendors, and they don't want to give us the proprietary software that would help us explain to you why you were stopped for that particular reason. These are all real examples that I'm drawing from, right? And there's no obvious answer in our conventional legal analysis about policing and whether we're talking about the Fourth Amendment or Article 1, Section 7, about how to resolve these kinds of clashes. And that's just the beginning. We might say that, imagine the government identifies one person as the perpetrator of a crime through the identification of that person and a supposed match in what had heretofore been a difficult to analyze DNA sample. It has the DNA of several people in it. Well, the defense attorney in that case wants to say, well, we want to challenge this. I want to see the algorithm that was used to identify my client. And the government says, we can't. It's proprietary. Also, details from a real case. How should courts resolve these kinds of issues? I think when privately developed tools police use today have this kind of impact, courts really have to think hard about which values, there's no obvious way to resolve these clashes, ought to prevail, whether it should be the IP rights, the private interests of these private developers, or the clear, long-established traditions of respecting the rights of criminal defendants in these cases. So right now, recall what's been brought up this morning. We've already talked about bias, how it can be introduced in the very data that is used to train algorithms, in the very factors that are relied upon to create the algorithms, in the very questions that are used to design the algorithms. In policing, what's happening right now is that all of those decisions are being made by private companies. And police departments are simply customers of these private companies. And because policing in the United States is largely a local function, there's no single approach here. So as far as I know, there are approximately 260 law enforcement agencies in the state. And that means there are at least potentially 260 different decisions about what kind of contracts can be entered into, what kind of IP licenses might be entered into, all of these very difficult questions that will eventually percolate through the court system. So I think that this is really an opportunity for the courts to sort of think ahead about, well, what will these cases look like, how they ought to be resolved, et cetera. And all this sort of, I think, can be summarized in, I'll sort of briefly paraphrase a quote from Justice Alito in the United States Supreme Court of United States of Jones from 2012, where Justice Alito said something like, previously there were natural brakes on government overreach, and that was community oversight, right, and practical resource limitations. In other words, people can see what's happening in front of them when there's an abuse of police power, let's say. Or sometimes police simply can't be everywhere, and that's a natural constraint. We are now watching, with the use of AI, a slow, or I should say, shouldn't say slow, a rapid elimination of those natural brakes. And this is the kind of opportunity that we've seen in the past where courts have stepped in and said, it's time to rebalance this inequity that we see here. So I'm happy to answer further questions in the Q&A period.
Hello. Thank you very much to the Commission for the invitation to be here, and it's an honor and pleasure to address the justices. My name is Solon Barocas. I am a researcher at Microsoft Research and an assistant professor of information science at Cornell University. And I've done a lot of work over the past 10 years now, I guess, looking specifically at questions of fairness and discrimination as it relates to artificial intelligence. And I thought what I would try to do is maybe look at a slightly different area of law that has not been covered as much in the comments today so far, although I'm very pleased to be on such an among such august colleagues today. In particular, I'd like to talk about discrimination law and the many domains in which artificial intelligence, and in particular machine learning, is entering domains covered by discrimination law. That includes, maybe unsurprisingly, things like employment decisions, credit decisions, insurance, but also things like admissions decisions as well. And to the extent that we can think of these tools as sort of replacing a bureaucratic procedure about allocating scarce and desirable resources, I think it's important to come back to a point that was raised earlier today, which is both what is the baseline and how should we think of these new technologies in comparison to human decision makers? And I'll try to make 2 points to start. I think first it's important to understand that we should not think of these tools as sort of doing the exact same thing that humans were previously doing. First, in the sense that these are actually institutional processes that are now being automated. They're not simply discrete decisions being made by individuals. So the process of deciding who is going to receive a loan, who will be hired, traditionally this would follow an elaborate bureaucratic process that had certain mechanisms for accountability and for review. And it's important that we understand how things are actually different when that process is sort of collapsed into these automated decisions. And so I encourage us not to think of these tools as sort of doing what humans have done previously, but actually taking on a whole entirely diverse set of functions that were previously handled by institutional procedures. The second point I wanted to make about this is that it's important that we also recognize that when these tools are seem to be replicating human functions, they may not be doing it in the same exact way that humans actually perform those functions. And so you might have been familiar, for instance, with this example of IBM Watson playing Jeopardy a number of years ago. And people recall this case because it actually made a mistake toward the end of the show where it sort of gave a seemingly nonsensical answer to a question. And so it wasn't simply wrong in the sense that it was sort of giving the name of another important historical figure. It was something that was just sort of orthogonal. And this is a very telling kind of error because these systems do not have the kind of broad knowledge of humans that allow it to understand contextually what is relevant. These are narrowly trained to perform certain tasks, and the kind of errors it can make as a consequence can be radically different. They could be somewhat alien. We don't understand why this is actually the error they are making. And so again, it's really important for us not to confuse these as human decision-making systems that simply happen to be automated. The actual reasoning in these systems can be very different, and I think that poses very important and challenging problems for the law. I also want to come back to, I think, this important question about intent. So what's been interesting about working in this area for a number of years is moving from a sense that perhaps what we should be concerned about are nefarious actors who might have goals that we see either as distasteful or we actually recognize as being unlawful, to recognizing that even well-intentioned actors who are using these new tools might discover that they are replicating biased behavior or unlawful decisions. And so even well-intentioned engineers, for instance, might find themselves party to a system which is producing unlawful outcomes. And so I think this is an interesting question for discrimination law in particular. So we can think, for instance, of the two doctrines that are relevant here. And if we think of disparate treatment, it seems almost trivially easy to satisfy the traditional requirements of disparate treatment because we will simply not include the prescribed feature in the model that we build. We will not allow the model to see race or gender, for example. And to the extent that we actually believe that the engineers who are working on these tools do not have the intent to discriminate, which I believe is most likely the case when people are working on these things, then disparate treatment seems to be a very easy issue to get around. That leaves us then with disparate impact. So if this is not intentional and not the actual result of malicious intentions or an animus, what is the role of disparate impact as a doctrine? And here, this is an area that I've done some work with my colleague Andrew Selbst, a legal scholar. And I think one of the interesting challenges here is that if we look, for instance, at the EEOC guidelines, which is often where people look even when we're considering other discrimination law, one way that we might justify a disparate impact that results from any kind of decision-making procedure is to show that the tool we are using has been validated, statistically validated, in the sense that we can show that it has predictive validity. By definition, machine learning will demonstrate predictive validity. And I'll try to explain why this is the case and why this is actually slightly confusing. The traditional concern, I think, that legislators had in mind when drafting this law was that someone would sit down by hand to write a rule, given their sort of assumptions or beliefs about what are relevant factors when making some important decision, and it may turn out to be the case that this heuristic that they have encoded in the rules is actually just faulty or perhaps discriminatory, even prejudicial. And so the idea that we might ask for statistical validity was a way of asking whether or not this set of rules that we've developed for making decisions actually predicts the outcome we care about, or whether it just happens to do a bad job, a necessarily bad job. And what's interesting about machine learning is that it is actually learning the rules from historical examples. It is literally learning what are the factors in past cases that have proven themselves predictive of the outcome I care about. And it is only those features which the model will then incorporate into the set of rules it will apply in the future, which is another way of saying that only those factors which demonstrate statistical validity will be the ones that are considered in this model. And so by that logic, you could see that if statistical validity is the basis upon which you can justify disparate impact, almost definitionally, machine learning models will do that to the extent that we think some minimum threshold of accuracy is met. But as many of my colleagues have talked about today, there are reasons to be suspicious about the traditional validation techniques that we have used, both historically and even when we're using machine learning models. In particular, if the data that we are using to train and to evaluate our models have incorporated bias on the part of past decision makers, there's no way for these models to actually discover that while it's making predictions that are true given current circumstances, it is still unlawful, in the sense that the decisions that it's learning to correctly replicate from the past were themselves illegal. So I think the challenge here is that we have to actually figure out how to push beyond the traditional standard of evaluation for these models and say that statistical validity is not itself a way of proving that this is a justified disparate impact. And I'll just kind of conclude it because I want to leave sufficient time for discussion, that this also encourages us to think about how do you actually justify decisions that rely on machine learning. And one of the important challenges that has been mentioned already so far is the concern that maybe these models are inscrutable. both to the people who might be using them, but even to the people who develop them. And I'll just mention very quickly that among engineers, there's a common belief that there is a trade-off between the performance or accuracy of the models that we can develop and their complexity, which is another way of saying that should we actually want to aim for accurate decisions, we may have to pay the price of understanding how those decisions are made, which again, from a legal perspective, can be a very troubling finding. And so there's a considerable amount of work that's happening within computer science that is now leading to discussions in law about how to deal with the question of whether or not we can evaluate when these decisions are justified if we don't really understand how they are being made. And I'll just simply make a final point that there is relevant law here as well. So the Fair Credit Reporting Act and the Equal Credit Opportunity Act, of course, has a provision for giving people an adverse action notice. This is when people have applied for credit and have been rejected. And lenders actually need to give reasons for why they have rejected applicants. And it is notable that the system we have in place here allows people to find out information about the data that has gone into the decision by accessing their credit file. We also allow people to gain access to their credit score. So this is the kind of inference that is made using the data. But we never actually have visibility into the credit scoring model itself. We do not know how the inputs are transformed into the output. And that is often where I think the kind of normative discussion rests. How are you going from making decisions using these given inputs to a highly consequential decision that you have to justify? And here, historically, creditors have tried to kind of content themselves with a very fixed set of possible answers, saying something like insufficient credit history, or you've only resided in a particular location for some amount of time. What's important about this is that this might be practically instructive. We can tell people what they might do to potentially improve their chances of obtaining credit in the future, but this might not be the mechanism that we want if we actually want to have greater accountability for the decision itself. If we want to understand more generally how these important decisions are being made, not just allow individual people who've been subject to the decision to make tiny adjustments around the margin. And so I'll just conclude there. Thanks very much.
With regard to policing and AI tools for policing, do you see any unusual legal challenges that courts will likely need to address in the future in evaluating policing AI? And I'm particularly interested in Fourth Amendment, but anything beyond that that you can think of as well?
When it comes to the sorry, can all of you hear me?
Okay. Hold it a little bit closer. Thank you.
Okay. When it comes to the development of AI and the Fourth Amendment, I think as my earlier remarks suggested, there are going to be some challenges even getting to the information itself. I think that's one of the biggest challenges that courts will be facing everywhere. How to access the very information that the defendant is trying to challenge in these kinds of cases. And that, again, as I've mentioned before, is going to need some resolution about how to balance what are clearly rights that corporations have over their own properties and their products versus the rights of the defendants to have full access as possible to the information that the government is using against them. That's certainly one big issue, and I've made that very clear. I think the other challenge that we see is something of not a challenge so much for AI, but I think that the increasing use of AI is going to expose search and seizure law under the Fourth Amendment or under state law as kind of showing us that it was always rather loosey-goosey ambiguous from the start. That because the legal definition of suspicion, whether that's reasonable suspicion or probable cause, has always been premised on this idea that a human mind made that decision and that we can't always understand fully why that officer, for example, decided to stop that person. That's part of the reason, I think, that the United States Supreme Court has never mathematically quantified probable cause or mathematically quantified reasonable suspicion. But what if AI were to do something for that? And so that way I want to make a positive suggestion that AI tools in the best sense might force courts to say, you know what, we need more exacting standards now. And these tools make those exacting standards possible. Now, that in itself is tricky, given all of the possible critiques that we've heard about this morning. But certainly one of the things that we want to walk away with, I think, from this morning is it's not all gloom and doom. There are questions that need to be asked, but there might be some really positive developments here that can force courts to say, you know, the doctrine as it is now, based so much on the black box of a human mind, maybe we could just make the law more precise and accurate, or at least that would be one of my hopes, by looking at the fact that human beings are now looking at tools that could be amenable to at least more auditing, more analysis than we could of any individual human person.
Thank you. And I have a question for Professor Barocas. How should the courts and government more generally best engage with developers of commercial tools to understand their operation and influence their development?
Thanks. I'll try to pick up on a point that was made by a number of speakers this morning. And it's almost such a simple point that we sometimes forget to ask, which is, what is the problem that this tool is actually designed to solve? Or what is the question that these tools are actually answering? And we heard, I think, a number of important examples of why that question is so telling when we think specifically of pretrial detention. So are these tools actually predicting a very specific outcome? There's many possible explanations for why, for instance, someone might not show up to their court date. And some of those we might see as quite justified, where we have some sympathy for the reasons that they had a hard time getting to the court, whereas others we might see as actually trying to flee. And to the extent that we actually can make these distinctions, we should understand that these tools are not are not taking on board the granularity that we might want. And this is true in many other domains as well. I mean, we think of predictive policing. It's sometimes unclear what this prediction is actually doing. Is the goal to simply predict where some crime will happen in the future so as to deploy a police officer that will then arrest the person? Or is the goal to actually reduce crime? It's not so clear that these are exactly the same thing. And the tools that we might build, if the goal is to reduce crime, might look quite different than the tools we build that we're just trying to predict the likelihood that crime will occur somewhere. It takes a lot more thinking to actually get there. So I think when we are asking folks in government to ask difficult questions when considering taking these technologies on board, it is critically important to really press and ask, what is the question that you are actually answering with this tool? And I also think that there's a real opportunity here to do something quite straightforward, which is that we often have to rely on the claims of vendors because we either lack expertise or there's no kind of standard way of evaluating these tools. But I actually think that there is a relatively straightforward practice that people might consider, which is that you might actually have some set of decisions that you want the vendor to be able to automate or to improve, and you know what the past outcome of certain cases were. So you can give them some past examples where you hold back from them the outcome. For instance, did this person recidivate, for example? And you ask, what does your model say about this people? You know, not on your data, but on my data. And I know the answer and you don't, so tell me, what would your prediction be for these particular people? And so there's actually somewhat low cost, potentially not very technically sophisticated mechanisms that we might rely on to allow decision makers to be more informed in their evaluation of the claim of vendors. And there's many more things, but I think those two, for me, are the kind of low-hanging fruit.
Great, thank you. And I have another question for Professor Joe. AI systems seem pretty mysterious to most people, but we hear that they can be very accurate as well, such as a car navigation system picking just the right route to avoid traffic. Given that AI systems can work very well, how important is it that people understand how AI works? And in particular, in the judicial context, when is it important for judges and parties to the case to understand how AI systems work that are being used to help judges make decisions?
So I think it's extremely important for judges and justices to understand what sort of questions have to be asked. Anytime AI is going to be sort of a prominent issue in a particular case. So I absolutely applaud symposia like this. I know that there are efforts around the country to educate prosecutors and defense attorneys with respect to criminal justice questions about what they should know about AI. So let me give you a kind of example. Again, to use a policing example, let's say that a police officer stops a person on the street, engages in a Terry-like stop, and based on a facial recognition match, supposed one, thinks, maybe this person is a match for an image captured at a bank robbery. Well, if that person actually is not that person, turns out later, but it ends up in trouble for another reason, they find some, illegal drugs on his person and arrest him anyway. He wants to challenge the basis of the stop. He says, I want to challenge the facial recognition. So this comes up as a court case. So what's the question then? Was it a good match? Well, I think it's important for a judge to say, when the police department adopted this facial recognition technology, what confidence level did they have? Did they set to have matches for the image at the bank robbery? Was it a 99% confidence interval? That's pretty high, right? That's a good match. But what if they used 51%? Well, would that be good enough to justify the stop? What if they used 10%? Would that be good enough? Because after all, we've always thought, or at least I've understood, Terry stops to be premised on a relatively low threshold, right? I don't think we've ever thought of Terry stops as being 51% confidence, but boy, now if we can assign a number to that, right? That would be interesting, and I think important in clarifying how certain these kinds of programs must be before police can use them to interfere with the civil liberties of individuals. But without knowing which questions to ask ahead of time, that becomes a very difficult issue. So I think lots of conversations among judges to discuss what are the basic terms of art that need to be used here are incredibly important, as well as for all of the other actors who come before you in legal cases. But that's just one example of how just focusing on that one question, what was the confidence interval that you use, can really, I think, be a key issue in any particular case like that.
If I might just jump in on that one. So I agree completely that transparency on how these systems work will be critical in any area where the system will have a significant impact on people. And I will give you an example from the healthcare space. So colleagues of mine at Microsoft Research years ago were working on an AI system to try to predict among people who had pneumonia, who among those people were most likely to have complications that would require further treatment. And they built a system on what's called a neural net, which is a very fancy system that's notoriously hard to understand how the system works. And it appeared to be very accurate in predicting who would need more care. But because the system was mysterious, the researchers felt like they didn't really understand it, and they didn't think it was safe to use in production, in the real world. So they built a simpler system that was more in the language of AI interpretable. It was more of just like a straight kind of linear equation with many, many variables. And it was almost as accurate, but they could see how it worked. And when they checked out how this system worked, they learned that for people who had asthma, they were at a lower risk of dying from pneumonia. And this made no sense because actually asthma is a risk factor for dying from pneumonia. And when they looked into what's going on, what they found was because doctors know that asthma is a risk factor for dying from pneumonia, patients who had asthma were more likely to be readmitted to the hospital, where they received excellent care, and then they actually had better outcomes than people who weren't admitted to the hospital. But in the training data, there was not a line for was readmitted to the hospital. And this was obscured by the deep neural net where you don't understand how it's working, and when they built a simpler model, which was almost as accurate, then they could see it. So that's obviously a very important example in healthcare, but it would apply in the judicial area, it would apply in credit, loan scoring, and employment, and many other areas.
Can I ask a follow-up question? And it dovetails, I think, with what both of you were saying. As I'm listening to all of this, I'm wondering, in so many areas we have, whether by statute, whether by court rule, in the judicial system, kind of a set of principles. Like in the medical field, we have institutional review boards. If there's going to be human subject research, you have community cross-section of folks. And Professor Joe, in the criminal setting, you seem to be talking more about kind of the substantive rules, maybe for what constitutes a Terry stop. But I'm aware that some courts, Oregon, our neighbor to the south, has used a court rule to eliminate certain eyewitness identification just on a threshold of admissibility. So is there anything like that that's going on institutionally in the development of these technologies or the deployment of these technologies where people are working on not just training, but like a regulatory framework for you've got to do this? And if not, do you think it's a good idea? That maybe we need something like, a mandate for an institutional review board or something?
I would say the answer is yes.
I don't think your mic's on, Mr. Heiner.
Let me try this one. I think the answer is, that's different. The answer is yes. I've been engaged with sort of the global community working on these kinds of questions for a few years. And I would say that over the past 3 years or so, most of the focus has been on identifying what are the concerns relating to AI. And we're just moving to the stage now of moving toward, so what are the principles we should be working toward to address those concerns? And I put the Microsoft version of those principles on the screen, but as I mentioned, the OECD is announcing a set, this week, and other civic organizations have principles, and other AI firms have principles as well, and they're not all that different. And so at some level, I feel like there is a societal consensus emerging around what we need to work toward. Now, of course, principles are like, the First Amendment is a principle, and there's a lot of case law under the First Amendment. How do you actually apply it? So speaking just for Microsoft for a moment, we're just at the stage now of trying to take the high-level principles I put on the screen and turn them into guidelines and rules for our developers, of whom there are tens of thousands, and they're not walking around every day totally focused on these subjects. And so we need to make it concrete for them and actually give them software tools to help them do a better job. I will give you an example of this from the gender shades study that Laura referenced. So this was the facial classifier that could look at a person's face and make a prediction, are they male or female? And as Laura put on the screen, researchers showed that although the system was highly accurate overall, and that's what the Microsoft team felt good about when they put it out, if you look across all people, it's a great tool, it works very well. But when you looked at the intersections, it turned out in the Microsoft case, which was among the better of these facial classifiers, the error rate was 20% for dark-skinned women. So the team was not sufficiently focused on the need to go back and look at things like intersections. So we're writing guidelines that say you need to do that. In this case, the team went back then, and as Laura was saying, part of the issue is in the training data. They went back and got more training data of dark-skinned women who had been already tagged as, dark-skinned people who had already been tagged as male or female, which was somewhat challenging to do actually. But once that additional data was available, then the error rate was reduced from 20% to 2%. So it's a huge improvement, still not as good as for white people, but a major step in the right direction. So this is a case where, we needed to sort of sensitize our developer teams, and we're in the process of doing that now, building out guidelines across all those principles that I had on the screen.
It's an interesting area because on gender, we're re-exploring what gender is anyway, yet the test that you're using is a binary one, which doesn't incorporate that at all. So.
Absolutely, and so I didn't even get into that aspect, but one aspect of fairness is saying as to any AI system, in the first place, is the objective function, some people have used that term here, is the objective of the system fair in the first place? And some people would say, look, we see gender around us, and so it's not unreasonable to have a classifier. And other people would say, Some people are non-binary, some people are transitioning, and there's very low likelihood that a machine's going to be able to make fine gradations of what someone's self-identity is, and that's true. So this is a case where, again, we sort of need to decide as a society, how do we want these tools to work? And we are in a case, which this is very common, the technology is ahead of the regulation.
But often what drives the technology is what the developer thinks the developer can sell. So don't we need to change it so that if we're talking about the principles and the values, so that we're measuring something that we value rather than something that is valued monetarily, because that seems to drive it right now.
Right. So we're living in a capitalist country, and there's demand for these services, and so they're being built. But regulation will catch up over time. We're seeing that now. It's in the news every day in a closely related area, which is social media, where that sort of burst on the scene in 2005, 2010, 2015, and we get to the point where today there's more than 2 billion people on Facebook, which apparently means there's some real value there in seeing photos of your grandchildren or whatever. And yet we're seeing the likelihood that social media is contributing to polarization within our country and other countries. We're seeing it bringing out sort of the worst in human nature to some extent. We're seeing it being used to spread hate speech. You know, I was in Auckland in New Zealand just 2 weeks after the Christchurch shooting, and the anger down there around social media companies was really palpable. And you know, we have a situation now where in Germany, it was in the news today, in France, they're moving forward in really regulating hate speech online in ways that we might not do in the United States, given our greater emphasis on First Amendment values. But this is something where society is now catching up. Social media exists. It's become a huge force. It's ahead of regulation, but now we're starting to see problems and we're moving toward regulation.
I was wondering if Professor Joe has any comment about the question that Justice Stevens had about eyewitness identification and admissibility and standards.
Sure. So the same question. I think in the policing.
No, that was on.
Just closer.
Oh, like this? Okay. I think in the policing context, the answer is there are two answers. For outside organizations, such as the ones that Logan and Laura are part of, there's been a significant amount of calls for oversight, the development of potential guidelines that could be used for law enforcement agencies when they want to adopt such policies, the kind of local oversight that should exist. And then there's the other side, which is, have they actually been adopted? And the answer, for the most part, is no. I think there are complicated political reasons for that. But as much as I hate this hackneyed phrase, it is kind of the Wild West of policing technology. The idea that lots of these AI programs are out there for sale and can be adopted and used without a whole lot of oversight. And again, I'll refer back to this idea that there's also a layer of secrecy that sometimes exacerbates that as well. So substantively, I think there's a long way to go for states and the federal government to try and attempt to place some substantive constraints or principles, such as what sort of consideration should be in place before a local law enforcement agency adopts an AI program to identify suspicious behavior, for example, and what kind of information would then be admissible in a court. All these things are complicated issues that ought to be addressed but still have not yet been. And that's just the tip of the iceberg, of course, because, you know, one of the technologies we haven't addressed too much so far this morning is AI and cars, autonomous cars. That will be an issue in law enforcement as well. Even though there isn't a current use of it right now, there's a great deal of technological interest and law enforcement interest in the possibility of doing things like remotely stopping cars, right? And this gets to a legal issue. If you can remotely stop a car, well, what if you can remotely stop 10 cars? What if you can remotely stop 100 cars? boy, that starts to sound like a reasonability question, right? That we're going to have to think about in terms of the legal community. Well, should we have that kind of technology in the first place? Isn't that a substantive kind of question? And that's one of the things we also haven't addressed. We spent a lot of time this morning talking about the minutia. You know, how should this technology be used? What's that kind of questions? But there's always the first principle question, and that is maybe sometimes we don't use the technology at all. Or we just say there's a prohibition on it until we develop X, Y, and Z principles. So those are some different ways of thinking about that problem.
I have a question for Dave. You were talking earlier about some ways that AI can help people. And I was wondering, what about challenges faced by people who can't afford a lawyer, who are going into court pro se?
Right. So, as you all know, we have a substantial access to justice gap in Washington State and nationwide, and of course, this disproportionately impacts low-income people and various minority communities. And it feels like a chronic problem. It's really not getting better. And, you know, since in America we're a highly legalistic society, matters that get resolved in other ways in other countries, we do through the courts, whether it's domestic violence, divorce, landlord-tenant, consumer debt. These things go to the essentials of life, and yet for so many people, they don't really have effective access. So what techniques have we used technologically in recent years to help address this? One is just providing information on a website. So it's nothing particularly fancy, but that's helpful. If you're out there with a legal problem, you can go to the web, you can get some information. That's good. A second step is online legal forms. And here in Washington State, we're just moving forward right around now with putting online family court forms. It's really, really helpful because if you're on your own and you've got some kind of family law problem, and there's a form, this is just so basic, but it tells you what you need to show for whatever you're trying to achieve. And so we've automated that. But that's all very basic. The question is, can we do something more with AI? And I think we can. And in fact, Microsoft has worked with the Legal Services Corporation and with Pro Bono Net, which is a national nonprofit whose board I chair, to build a prototype of a system that is designed to enable someone to come forward in just natural language and state what their problem is. And then the machine would be smart enough to understand, like, oh, okay, we're talking landlord-tenant, and maybe even ask a few questions, like, why are you being evicted? And the person would say, well, landlord says it's because I didn't pay my rent. And the system could come back and say, well, did you pay your rent? No. Why didn't you pay your rent? Well, there was no heat. And the system could be smart enough to know, okay, well, now we're getting someplace. The landlord needs to provide heat. And then direct people to resources to help themselves. So we've built a prototype of this system. It's now with the Legal Services Corporation. They will roll it out as a beta test in Alaska and Hawaii in a few months, and we'll see how well it works. It's far short of having a lawyer. It doesn't have human judgment. It's not practicing law. But it is helping people to sort of make sense of all the resources that are out there and point them in the right direction. So I think it's a nice example. If it works, you know, again, it's going to be a beta test, a nice example of how we can use AI to get after a range of societal problems.
You know, it's more of a comment than a question in the sense as I'm listening because I want to be a tech optimist, and I've kept saying that in our planning process. And yet, our branch is treated on par in the same manner as a private consumer of AI, in the sense of we don't have the resources, we don't have the capacity, if you will, to work with engineers or designers, just because we don't have money to be able to, say, design something that's going to enable us to really be more effective, right? Whether that's making judicial decisions or providing a larger portal for people to access the courts. And that becomes so awfully tough because I know our judges are innovative, creative, got a lot of ideas, But without the resources, we can't even begin to sit down and try to develop tools. And we'll always be grateful for the assistance on the LFO calculator, because it's made a difference for thousands of people already. But boy, that was just right by sheer luck, a grant, and running into some talent like RC.
Yeah, and I really feel like it's almost like low-hanging fruit to use technology to help solve some of these problems. The LFO calculator that RC worked on, it's pretty basic, actually. It wasn't that hard to create, and as you say, it can be so beneficial. But as you know, budgets are so tight for legal aid. It's not a popular subject. The Legal Services Corporation, President Trump has proposed cutting it to zero twice. Congress didn't agree, but the budget is not growing.
Just also to address this, I think what we're sort of also talking around is that AI on the law is an enormous public education project, not just for the judges, not just for the legislatures, law enforcement officials. We're sort of in the policing discussions we've had today. We've talked about, they shouldn't be using these biased data sets or these obfuscatory algorithms, but they also need to be educated as well. I mean, a very quick anecdote of this is I spoke to a law enforcement official who was a chief who was very interested in AI, and his response to me when I asked him about it was, all I want to know is it going to work and is it easy to use? And I said, there are so many other questions there besides that, but that's a well-intentioned person who wants to know more. And, these are small departments that don't have chief technology officers. They need guidance, whether it's from the courts or from the legislature. They need to know what are the questions even a responsible public agency needs to ask. And I think that's absolutely imperative for government to do.
Just to complete this thought, I'm also quite optimistic about a lot of this. I mean, specifically in areas where there's been profound rates of discrimination, in particular in employment. Despite the many problems with these tools, there seems to be a serious opportunity. It will require careful thinking, but I do want to come back to an important point that Justice Gonzalez raised, which is, if the baseline here is human decision-making, should we be evaluated against that baseline? And I think that is an important point, but I also think there's a separate question, which is, even if this is an improvement over the baseline set by human decision-making, is it lawful? In the sense that perhaps these tools are doing better, but they still might be discriminating. So I want to encourage us to also think about not new principles or brand new kind of tabula rasa questions about how do we regulate these things, but even just basic questions of law. So how do we actually make sure that the people using these tools know how to understand whether or not they're meeting the legal requirements? How do we make sure that courts actually know how to ask the right questions to determine if these are meeting legal standards or the legal principle? I actually think there's a considerable amount of more work to be done, not on new principles, but just understanding how to apply existing laws effectively.
So it seems to me that a lot of what you've talked about today is the fact that the data that these systems are going to rely on is really not good data, in the sense that it reflects biases that have come before. And so to the extent that we want to use these technologies, is the most important first step to clean up our act, so to speak, that is with reform, system reform in just the old-fashioned sense of it, and then sort of go to AI and with this better set of data? Or is the marketplace what it is and we're going to just get these products, they'll be produced, courts will buy them, law enforcement will buy them, and there's really nothing we can do about it. We don't have an FDA for AI. It seems to me that we're kind of a chicken and an egg here. Am I seeing that right?
That's an excellent question. I've looked a little bit at the area of employment where there's a fair amount of activity to develop tools with the express purpose of trying to mitigate human bias. And so vendors are beginning to make quite strong claims that these are mechanisms to either reduce or eliminate bias completely from the hiring process. And what's troubling here is that these are claims that are not often supported by evidence, or it's not really clear what the word bias means in those particular claims. And I think the degree to which we can help people evaluate critically some of these claims, and in particular, the degree to which courts or lawyers are bringing cases that allow us to actually probe at this, I think that then puts pressure on industry and vendors to actually be quite precise and forthcoming about what they're actually doing when they're saying that we're trying to clean up our data, which I think many of us now realize we have to do. But what that actually means, it can be quite variable. And at this moment anyway, there's not a lot of precision when people have adopted the language of fairness or anti-bias mitigations. And the interesting thing I'll kind of end with is that there's a considerable amount of work happening within computer science to try to give precision to these terms. And I think it was Shankar who mentioned that there's a wide diversity of definitions of fairness in the computer science literature. Rather than seeing these as tools to sort of be done with bias once and for all, we should realize that we're now able to kind of ask vendors who are using some of these tools, well, which of these have you adopted? What do you mean when you're actually trying to ensure that this tool is fair? And that, I think, gives us a place to then have a much more informed debate or discussion about whether or not we think that's adequate, whether there needs to be other things done. But right now, we haven't yet gotten to that stage, and I think the courts and lawyers could be very effective in bringing that about.
We're drawing close to the conclusion time, and so I would like to make a few closing remarks. First, as mentioned at the beginning, our state Supreme Court is the only one that annually holds this symposium. But the reason we hold this symposium is because of the Minority Justice Commission and the excellent leadership that Justice Mary Yu and Judge Helen Whitener provide. They are ably assisted by Cynthia Delestrinos, who, as mentioned, stepped in and took on a more laboring oar than was originally intended or expected, and she has done an excellent job. I want to thank all the speakers today. It was just a fabulous morning, a very well spent 4 hours for us to hear from you. The welcoming remarks both by Justice Yu and Judge Whitener, but then Shankar Narayan and R.C. Carter explaining to us understanding artificial intelligence and bias within artificial intelligence. And you thought it was basic, but I think it really set the groundwork for us to understand. And we all come with different backgrounds of experience and understanding. The pretrial risk assessments by Logan Kepke were very interesting, and we're always looking at pretrial and post-trial and trying to understand how we can have a fair and equitable system. The equity and policing technologies that Laura Malloy shared with us, and looking at predictive policing, face surveillance, and cell site simulators. Some of the cell site simulators I was not aware of, and so that's very interesting to me. And then this panel discussion moderated by Judge Teresa Doyle, I thought was so interesting, both the opening remarks by Dave Heiner, Elizabeth Joe, and Salon Barocas, but then the conversation that you had both with each other and with us, I think will stand us in good stead. The one, I've written down many pages, both on your outlines and those who did not have PowerPoints, but I was really struck and wrote down that technology is driven by our values, and our values are part and parcel of technology, Shankar's remarks earlier. And so part of this is SI values as a judicial branch, and taking those values and being sure that in all aspects of our work, but especially in these new, emerging, trying to understand, trying to keep up, where regulation and government oversight is lagging, the duty and responsibility that we bring to these conversations and these discussions as they're presented to us in cases, but to really have a morning that was filled with education and training for us, which we have to have that to be able to bring thoughtful deliberation to the cases that will be brought before us, because so often cases are limited to their facts. And so for us to have a broader base upon which to build. I also want to thank Jessica Gonzalez, Beverly Tsai, Justice Yu's extern, Jessica being Justice Yu's administrative assistant, Guy Rosser and Tyler Williamson, all of the law library staff, and especially Rob Mead, the law librarian, and Ellie Crumwide. And I also want to thank TVW and ProLumina. I thanked them personally yesterday when they were in here working mid-afternoon, and they stayed late to be sure this would go perfectly this morning. They have been with us for every single symposium, and it is a wonderful service that you provide in allowing us to have this technology so both people in the room, the justices, and people at the remote sites can see. And TVW is our partner in bringing the courts gavel to gavel, and today I actually used the gavel I don't normally get to the people of the state of Washington. And so you can be assured that people will be watching us because they will play us now that the legislature has gone home for this session. And you can stream it, so you don't have to wait to follow the TVW's broadcasting schedule. You can go home right now and see, but speakers can see how they looked on TV. But I'm going to go back and listen to it, because while I took notes, sometimes the terms or the speed, I maybe didn't fully comprehend it. And it's really important, I think, that we spend the time necessary to educate ourselves on matters that are so important. So again, thank you to Spokane for tuning in, and the University of Washington Law School. I'm not sure how many people are attending, but I hope that it has been as interesting and informative for you as it has been for us. There is a reception sponsored by the Minority and Justice Commission immediately following this session. It is in the Chief Justice's reception room, which you get to by going out these doors, turning left, and then doing another left, and you'll see an entry into it. I will not be attending the reception. I have to leave immediately for a medical procedure, and so do not take my absence as any lack of my desire to have had the opportunity to individually say hello to you and to thank you, especially the Minority and Justice Commission members, but all of you who took time out of your busy schedules to attend today's session. So I look forward to visiting with you in the future. I know my justices, my colleagues, the gang, the team, will join you in the reception room and express to you their personal gratitude. But on behalf of myself and all of the justices of the Washington State Supreme Court, I want to thank everyone I have thanked, and you, for being here and for making this such an important, educational, and informative session. And with that, with 2 minutes to go, I will adjourn.